We're live.
Okay, excellent. Thank you very much. All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 2nd, 2021. We have 7 bills on the docket today. We'll start off with Senator Sydnor with Senate Bill 587. We'll then move on to 781, 628, 724, 832, 892, and we'll wrap up with 911. So with that, Senator Sydnor, I'll turn it over to you with Senate Bill 587. I like the shape up with the beard. Looking good. Here you go.
Mr. Chair, I appreciate that. Good afternoon to all the members of Judicial Proceedings. For the record, Senator Charles Sydnor speaking in favor of Senate Bill 587. For those of you who know me, for a number of years, I've been trying to get at how we deal with the technology that's coming into and being used by law enforcement, whether it be our cell site simulators or genetic genealogy or even body cameras. I've always had an interest in trying to make certain that we were using these technologies in a way that was not abridging citizens' constitutional rights, but also ensuring that questions that we had about technology were rightfully answered, and that there was a transparency in how we go about or would go about having these different technologies adopted by law enforcement. So a number of years ago, as a member of the House Judiciary Committee, I'd introduced legislation back then after a report that came out of Georgetown with regards to facial recognition. It was something new at the time. There was information that was published just talking about the unreliability of facial recognition, especially for people who were non-white. So that bill went down. I moved from that posture to a posture, I should say a posture throughout the country, moved towards outright banning many of these systems. I think last year I may have had a bill dealing with an outright ban, but it also had a bill that was similar to this bill that you're hearing today. It did not come to JPR last year. It actually went to finance because the bill, it encompassed the use of facial recognition software for both public and private entities. That's how it was drafted. After some soul searching during last year's session, I realized that, to be honest with you, facial recognition and its use in the private sector is like the genie that has gotten out of the bottle and extremely difficult to put back in. So I thought coming in this year, I would scale back the bill so that we were just dealing with regulating, not banning, regulating how many of our government agencies use facial recognition. If you were to look at my written testimony, I do acknowledge that there are many benefits to facial recognition when used properly, whether it be the monitoring of our high security events that I've heard they've used at the Super Bowl, whether it's the use of it as recent as January 6th in capturing people who stormed our nation's capital. There are benefits to this technology that I acknowledge. However, this technology has also been used maliciously. Some of you may know that one of the places that have used this type of technology maliciously is in China, where they have used this type of technology against this Turkic ethnic group called the Uyghurs. And they've been using facial recognition software to alert police that a Uyghur may be present, and they've been really discriminating against this population over in China. So Senate Bill 587 attempts to address some of the concerns that we have with the use of facial recognition. One being, and I believe one of my witnesses will speak to this, back in June, when all other things were going on, where we were focused on Minneapolis, there was a gentleman in Michigan by the name of Robert Williams. Robert Williams, he was arrested for shoplifting. And how was he arrested? He was arrested because of the use of facial recognition system. Now, mind you, back when I first put this legislation in, I had an opportunity to travel or had a real good debriefing with the Maryland State Police because they have what we would call they call a fusion center within Woodlawn, Maryland. And I had an opportunity to see how facial recognition was used. And one of the things that was mentioned was, look, facial recognition is nothing but a mere investigatory tool. And if you take that on face value, it's really nothing different than what police do today. You get a mugshot book, you get a suspect's photo from an array, and then you use that to continue finding evidence in order to determine one's guilt or innocence. If facial recognition was just being used that way, we may not need this bill. However, like I said, what happened to Mr. Williams is happening. Unfortunately, I found out that there was something that had also happened here in the state of Maryland, where it was not just a mere investigatory tool. And those kinds of things concern me. So what this bill does is it requires some quality assurance testing by our vendors. It ensures that law enforcement users undergo mandatory periodic training to ensure that best practices are always being used. It strictly prohibits political or the use of this being used in any way to go after political or religious, whoever that religious enemy may be, and as well as being solely used on the basis of race. So with that, I'm gonna be quiet and turn. Oh, one last thing before I turn it over. In the meantime, since we had first introduced this legislation, the state of Washington, with the help of Microsoft, they actually passed legislation that this bill is built off of. So it's not as if we're doing anything groundbreaking. I know the state police, they mentioned some sort of concern that if this bill passes, they would no longer be able to do what they're doing. That is not the intention of this bill. I'm not trying to stop the use of, like I said, stop the use of facial recognition, but we do need to put up guardrails that we just don't have. So with that, I'd like to have my expert witness, Ms. Talani from Microsoft. She will be our lead proponent, then Mr. Chris Dipietro and Mr. Andrew Northrup from the Office of Public Defender. Thank you.
Okay, thank you, Senator Signar. We'll have our first witness now, Pooja Talani. Go ahead, start your testimony.
Thank you. Good afternoon, Chair Smith and members of the committee. My name is Pooja Talani, and I'm an associate corporate counsel at Microsoft. Thank you for the opportunity to be here. We would like to thank you and Senator Sidnor for your leadership and efforts to restrict the government's use of facial recognition technology. Since July of 2018, Microsoft has called for new laws to regulate facial recognition technology, well before lawmakers across the country began introducing proposals to govern the technology. The company believes that facial recognition offers tremendous benefits for the society, security, and public safety. We also think it's important for lawmakers to ensure that the technology will not be used to undermine civil liberties, discriminate against members of protected classes, or otherwise harm marginalized communities. For those reasons, in June of 2020, Microsoft announced that we would not sell facial recognition technology to police departments until there are laws regulating it. Microsoft strongly supports your efforts to address these important issues, including imposing safeguards like accountability, transparency, training, testing, public reporting, and restrictions on use. However, we believe it is most important to listen to and work with law enforcement and civil society regarding regulation of such technologies. We look forward to hearing the perspectives of those groups and are willing to help in any way we can, including efforts to help foster a dialogue between those important groups today. Thank you for your time.
Thank you. Proceed with the second witness, please. That would be Chris Dipietro.
Madam Chair, members of the committee, Chris Dipietro here on behalf of Microsoft. Pooja, I think, laid out the position of the company, but I want to backtrack a little bit. Senator Sidnor, I think we all know, does his homework on legislation before he puts issues in. He reached out to me in the summer of 2019, knowing that he was interested in this issue and knowing that Microsoft was working on the policy side of this. So we worked with him through that fall, and last year there was a bill that was introduced that was a broader bill, which is why it went to Senate Finance, because it also looked at the regulation of commercial activity in addition to government use of this technology. I think where Microsoft comes from on this issue is that there has to be guardrails where none exist today. Right now, the law, as the fiscal note says, there is no laws regulating how this technology is used. We need to make sure that there's accountability in the system, that there's oversight and transparency. And I think once there is that trust built into these systems and how they are used, therefore, then you also get buy-in from the public about how they're used. I think, as the senator says, they could be used for good and they could be used for incriminating people that may not have perpetrated an act or be the wrong person. You want to make sure this software is used properly. And I think that's where we're coming from. Like Pooja said, we've been having this dialogue for 3 years now with national organizations to figure out a way forward that public trust can be there when government does use this technology. So with that, the other thing I've been doing since this started, since Senator Sidnor called me on that a couple of summers ago, is I've been tracking every time I see an article on this, I clip it. And just this past weekend in the New York Times, there was a great article talking about this very issue and what Massachusetts is doing on it. The governor there says he's not going to ban it. That's not an option. There need to be guardrails put in place. And I think that's the direction that Massachusetts is going in. We don't want to look for a ban. I think some municipalities across the country have banned the technology. I don't think that's the way. Like the senator said, you can't put the genie back in the bottle at this point. So with that, we are here in full support of this effort, and we hope to be a resource and continue the dialogue with all the stakeholders involved. Thank you.
Thank you, Mr. Dipietro. Now we have testimony favorable with amendments. Andrew Northrup of the Maryland Office of Public Defender. Proceed, Andrew.
Thank you very much, Madam Chair and members of the committee. I'm Andrew Northrup from the Office of the Public Defender's Forensics Division. First, I want to thank Senator Sidnor for his hard work in addressing and tackling this issue. The position of OPD is that we support the bill with amendments that we have drafted and tendered to the senator. Our concerns pertain to potential use of this technology in criminal cases and ensuring there are disclosure requirements for its use. The use of facial recognition technology by the government is a somewhat unnerving concept by itself, but when that technology is not held to the highest standards of accuracy and reliability, the results of its use can be quite dystopian. While some facial recognition algorithms have improved greatly over the past few years, they are not perfect and still vary quite a bit in their quality based upon the algorithm itself, as well as the race and age of the person being viewed. There are currently no set standards in place as to how accurate and reliable the technology must be before it is used by law enforcement. And also, even assuming a high quality algorithm, the results are only as good as the quality of the image that is uploaded. As I'm sure all of you have seen surveillance camera footage that varies greatly in quality depending on lighting, quality of the camera, angle, etc. There currently don't appear to be any set standards as to the quality an image needs to be before it is uploaded, nor do there appear to be any set standards as to image processing, meaning when the analyst rotates or lightens or darkens the image before uploading it to a database search. And unlike other forensic disciplines, there are no proficiency tests for the operators of these machines to ensure that the identifications being reported are accurate and reliable. This is why in other jurisdictions using facial recognition programs like Michigan, that was mentioned earlier by Senator Sydnor, where the misidentification occurred, results are considered investigative leads only. And we request that this be codified into law, as we in OPD have at least one case where they are using facial recognition software as the sole evidence against an individual. But even in Michigan, with such a policy, there's been that misidentification that was mentioned by Senator Sydnor. Because after all, that investigative lead was confirmed with a photo array shown to a witness. Because of situations like this, it is imperative that even when used only for investigative leads, that the use of this technology be disclosed to defense counsel whenever it is used in an investigation with the materials necessary to allow the defense to assess the quality of the investigative lead. That is our position. Thank you very much.
Thank you. Now we have the next witness, which is Scott Schellenberger. Unfavorable. Proceed.
That's correct. Senator Lee, members of the committee, Scott Schellenberger, State Attorney for Baltimore County, in opposition to Senate Bill 587. First, let me quickly correct one paragraph in my written testimony. I had stated that there was no exception for airports and seaports, and Senator Sydnor, I did miss that paragraph. So I want to make sure I get that out there. You did make an exception for that. However, I think this is a bill that really hampers police from using modern technology to catch people. For the last 100 years, when someone got robbed, we would walk them into a police station, put a giant book in front of them that had hundreds of mugshots and say, start turning the pages. All we are doing now is let the computer first start turning the pages. So let me tell you about how we solved a robbery in Towson several years ago. Two armed men went into a liquor store. During the confrontation, the gun was pointed at the liquor store owner. He pulled out a gun and shot one of the defendants, and unfortunately that defendant died. The other individual who was robbing him got away. They had no clue as to who he was. But what they did was they went from the other defendant who died, they went through his social media and found him with another individual who looked similar to what the owner said had happened and had been the other robber. So what did they do? They used facial recognition technology. They went through a whole database of mugshots and other things, and lo and behold, they come up with 702 photographs that possibly matched. Now what they had to do was good old-fashioned police work, and the detective went through every photograph and compared them to surveillance video around Towson where the two individuals were seen together. And lo and behold, a couple of years later, Hayes Sample was convicted of attempted robbery and sentenced to 20 years in jail. And what this bill does is severely hampers our ability to use this technology properly in order to catch criminals. So that's a very important and a good thing that's different. It's no different than what we've been doing for decades by putting people in front of mugshots and other photographs to learn how to do things. The other thing that I think is very important is on page 10 and 11 at 10.1710, it talks about in order to do surveillance, thank you, in order to do surveillance, you have to have probable cause. Well, if I have probable cause, I don't need surveillance. Most importantly, last thing I'll say, Senator Lee, page 11, number 3, it requires me to get a court order to use this technology to identify a dead body or a missing witness. What constitutional right are we protecting when I'm trying to find who this dead body is so I can notify their loved ones that they are deceased? This bill is way too complicated. It needs lots of work. I urge an unfavorable report.
Okay, thank you very much. And that is in your written testimony as well, right? Correct?
Yes, yes, it is.
Thank you. Our next witness unfavorable is Jake Parker of the Security Industry Association. Please proceed.
Hi, Jake here with the Security Industry Association. We represent companies providing safety and security products in Maryland and nationwide. Our members include most of the leading developers of facial recognition in the US. We support addressing concerns about this technology with policies ensuring it's used appropriately, and we would agree with certain elements of the bill. However, we believe as written, it would actually limit versus reasonably regulate many applications that benefit Marylanders, and as well as the adoption of new technology. It needs significant changes. Confusing terms and complex requirements would make compliance difficult for agencies. For example, the bill exempts using the technology for unlocking devices. It makes sense. There's no privacy or civil liberties impact there. However, the requirements would also be overkill for many other authentication uses, such as allowing an employee to unlock doors or access secured areas. The overly broad definition of ongoing surveillance that was just mentioned would actually prohibit day-to-day safety applications protecting staff and visitors in public buildings. It seems the restrictions would be triggered if a person is merely recorded at more than one place in one time, indicating movement, such as when a person enters multiple doors or throughout a facility. And this would require a warrant, even though the application has nothing to do with policing. The requirement for third-party testing is structured for cloud-based services available to the public in the details here. But the technology agencies usually use is typically not cloud-based. There's little protection against transferring proprietary information or inappropriate use by third parties. Meanwhile, the technology used by the Maryland Image Repository System is already independently and thoroughly tested by NIST and shows consistent performance across demographic variables. It's important not to disrupt critical public safety issues that Mr. Schellenberger was just describing. And just in a few other examples, was used to help the Capitol, identify the Capitol Gazette gunman in 2018, was later used to break up an organized crime ring in Montgomery County. Last year was used in Baltimore to help identify a suspect of a brutal assault on public transit. And just recently, obviously, helping identify several hundred of the attackers at the US Capitol January 6th. The bill's warrant requirements seem contrary to longstanding practice and deserve a second look. Definitely encourage additional feedback from law enforcement professionals in Maryland. For example, it could require an agency to essentially serve a warrant on itself in order to search records that it creates and maintains. And incredibly, it was just mentioned, would also require a court order even for locating a missing person, potentially a victim, not the suspect of a crime. And again, we agree with establishing safeguards. I think it's something important we need to do to make sure we have public trust that our agencies are using this technology appropriately. But many changes will be needed to appropriately. Thank you.
Thank you, Mr. Parker. Now we will take questions from our committee members. Are there any questions, committee members? Okay, seeing none, hold on. Senator West, please proceed.
Thank you, Madam Chair. This is a long and a very complicated bill. So I've started to go through it during the course of the testimony. And it looks to me like the first 2/3 of the bill maybe basically establish all sorts of procedures for validating systems, the facial recognition systems. Let me ask the Amazon people who testified, do you all make facial recognition systems? Does Amazon make facial recognition systems?
Are you talking about the Microsoft?
It's actually Microsoft.
I'm sorry. I meant Microsoft. Sorry. These technology companies, they get confusing. Go ahead.
Ms. Talani, do you want to go ahead and answer that question? Or Mr. Dipietro, either? Ms. Talani, why don't you answer that question first?
Thank you for your question, Senator. Microsoft is a vendor of facial recognition software, and through our internal processes, we make sure that any deployment and development of facial recognition software undergoes extensive consideration through internal committees and through guided by our AI principles.
And do you believe that the Microsoft
system that you all sell complies with the various standards set forth in the first 7 or 8 pages of this bill?
Thank you for your question. We have a long standing, as I mentioned earlier, of calling for legislation in this space because we are aware of the serious concerns that can arise with the use of this technology if there's not proper testing and if there's not proper training for this technology. So at Microsoft, we have undergone, like I said, extensive research within to make sure that if the technology is deployed, that there are principles that guide the deployment and development. But we do agree there are some serious concerns that can arise out of the use of this technology. That being said, we think we would leave it to law enforcement, lawmakers, and civil society to decide what regulations should guide this technology and the uses.
Well, that's helpful, but it didn't answer my question. My question was whether the Microsoft system that you sell would comply with the various policies and procedures set forth in the first 7 or 8 pages of this bill.
Apologies. Thank you, Senator. Our software as it is undergoes, like I said, we have the 6 principles that guide our development and deployment, and those do align with this bill. And like the Senator Sidnor had mentioned, this bill was passed into law in Washington State, so we are ramping up to make sure that our technology can comply.
Okay, so if this bill passed, Microsoft would be able to sell its systems to law enforcement organizations here in the state of Maryland, correct?
In June of 2020 of this year, Microsoft made a commitment to not sell facial recognition software to state and local police departments based on the conversation.
Assuming this bill's passed, Microsoft would be able to sell compliant systems under the procedures set forth or policies set forth in this bill in the state of Maryland, right?
To answer your question, like I said, we in June of 2020 made an announcement within as Microsoft that we would not be selling to state and local police departments unless there is a strong regulatory bill based grounded on civil rights and liberties that added protections. And if
all right, again, then, if this bill is passed, would this bill pass muster insofar as Microsoft is concerned?
I can't speak to that, but I will be happy to get follow up with you, Senator.
Okay.
Thank you.
Are you aware of other companies which sell facial recognition systems?
I'm not. Oh, sorry. Sorry, what were you saying?
Other than Microsoft, are you aware of other companies that sell facial recognition systems?
I can't speak to what other companies do. Thank you, Senator.
Maybe Mr.
I think Mr. Petro can answer that question. Go ahead, Mr. Dipietro.
Okay, yeah, I just wanted to jump in on that. Thank you, Senator West, for asking the question. Yes, there are many companies out there that are selling this type of software. And I think that is the point of the bill. The point of the bill is that they're not all created equal. And some are going to take the precautions like we are in Microsoft to make sure that the software that we are deploying and that we would put out into the market is going to meet some level of requirement that gives public trust. Now, whether or not we sell in Maryland, if this bill passes, I don't think we can answer that at the moment. We have to see what kind of, what happens to this bill. Obviously, there's going to be a lot of debate about what should or shouldn't be included in such legislation going forward. So we would have to wait until the final product comes out to make that decision. But at the moment, no, we are not going to sell unless there is some framework.
Didn't you work with the bill sponsor to develop this bill?
We did work with the bill sponsor. We helped craft it. Yes.
I'm hard pressed to believe that you worked with the bill sponsor to develop a bill which would not enable Microsoft to sell its systems in Maryland.
Well, again, we have to see what the final product looks like.
Well, let's assume the final product.
We're not the only state looking at this either. So
let's assume the final product looks the way the bill looks now.
I don't want to get into assumptions in that way, but Microsoft would have to make that call at the end of the day. And I can't say that definitively right here today.
Well, wouldn't this bill essentially disqualify some of your competitors from selling their systems?
I don't think that's the approach we're taking with this at all, Senator, with all due respect.
Perhaps Senator Sidnor can answer that question. Do you have a question for any of the witnesses, Senator Sidnor?
I did have a question for Mr.
Okay, please proceed then.
Thank you. This is for Mr. Parker. In your testimony, when you were talking about MyPower, you said that it performed consistently across demographics or something like that. would you mind elaborating on how it performed consistently across the demographics and what data you might be looking to make that statement?
Yeah, I was referring to the specific algorithm used in the Maryland Image Repository System. And so it's one of those that was tested by NIST back in 2019, was looking specifically at demographic performance factors. It's a lengthy report. I'm sure you're probably familiar with it. So what they found in that report was the highest performing technologies did not demonstrate any differences across race and other demographic factors. Now they found, truthfully, many others that did show some differences, all right? And that's an issue that needs to be addressed. But the highest performing ones tend to be those that are used by law enforcement and government applications. And what I was saying is the particular algorithm used in the Maryland system is in that high performing group. And more recent information actually shows that that algorithm performs slightly better for Black men and women than white.
Is it possible to share that report with me and the committee? Because that statement seems to go against a lot of the research that's out there that says that most of these systems perform in the reverse way.
Sure, I'm happy to do that. I think what NIST said in that report was they cautioned against drawing a blanket conclusion about all technologies. And I think the fact that they showed that some of them didn't have these differences means that it's hard to say it's inherent in the technology, but certainly it's an issue for some. I'm happy to share.
And I guess inherent in who it is that's creating. I mean, so each of the algorithms is going to be a bit different, right?
Well, no, I mean, so the leading technologies perform at a very high level currently. Accuracy rates are around 99%. That just wouldn't be possible if they weren't using diverse data to build them. It would be impossible.
Thank you. For Mr. Schellenberger, one of our, Mr. Northrup, he had made the statement, and I had cited from an article about a gentleman in Michigan where he was arrested, and from what I could tell, based solely on this identification made through facial recognition. My question is there anything that prohibits that from happening here in the state of Maryland, in anything in law?
Well, I don't know that there's anything that prohibits it. I can tell you that the way my police department works, and the ones I've been talking to who have utilized this technology, is that they use it to get leads, to lead us to a defendant. I would certainly work with you if there was a desire to block people from even introducing the fact of facial recognition technology was used to even getting the lead. I think that's a conversation that we can have. I think there are several other, reasonable accommodations that can be made. I can tell you in the Towson robbery case that I described, they got to the defendant through facial recognition, but the entire case that was presented had nothing to do with facial recognition. In fact, it was not even mentioned. And certainly I would think that that would be a reasonable thing we could agree to. But Senator Sydnor, as with everything, you tackle some very, very complicated subjects that take 10, 13, 15 pages. And sometimes, I hate to even bring this up, take work groups and task force, as you and I have worked on 3 or 4 of them together. I don't need another task force, but this is a kind of law that requires a lot of people at the table, including prosecutors and police agencies, particularly police officers who have actually dealt with this technology. So, but I do recognize that there need to be limits on what happens in a courtroom.
And if I might ask, since we mentioned Baltimore County, does Baltimore County have its own system, or does it rely on the Fusion Center for its technology?
So I think Mr. Parker mentioned, I think he mentioned MERS, which is the Maryland Image Repository System, Image Repository System. And that's a system in Maryland that most of the police departments I know can link into, in which they can run the surveillance video or the photograph that they have through the MERS system, and it kicks back the number of matches. And like I said, several years ago in the Towson one, they got 200 and or excuse me, 702 matches. My understanding is the technology has gotten better and the number of matches that come back have kind of dwindled down. But as we heard, it was just recently, that whole system was recently used to identify one of the individuals in the Capitol riots. So I think you'll acknowledge that it does have some value for us.
Oh, no, and I made certain to say that from the very beginning, and I made that statement to the state police. I was glad that the system was used in that way. One last question that I had with regards to access to mirrors and or the MyPower system. Does government officials have to have any special credentials in order to access that particular system?
That is something I'll have to check for you. The only folks that I've talked to who use it are detectives, who are actually in those units, particularly the robbery unit is where it's used quite often. But let me check that out and I will send you an email.
Thank you.
Great. Yeah. Okay, next question, Senator West, proceed. And then, go ahead, Senator West.
Thank you, Madam Acting Chair. So this is not a system that I'm very familiar with, to be honest with you. But I do know that there are all kinds of security cameras all over the place these days. There are security cameras, they're filming the roads, they're filming the highways, they're filming intersections, they're filming public buildings, they're filming schools, there are lots of private cameras on stores. So my guess as to how one of these systems would work is you would take film from, if there's been a robbery, you'd take film from cameras in the vicinity of the robbery, and then you would try to identify or take snaps of individuals on the film and then run them through that system. Mr. Schellenberger, is that how you do it? Oops, he's disappeared. There he is, but he's muted, I'm afraid.
There we go.
Okay.
Got it. Thank you, Ms. Pop. Senator West, you're correct, but we don't usually do a scan of a crowd, and I know that's one of Senator Sydnor's concerns. I think the better idea is that you would actually have a surveillance video of the person in the liquor store or just outside the liquor store. And you do need a fairly decent picture. So there are some surveillance videos that really would not qualify, particularly if you're far away on a street or something like that. So you would need something pretty decent, but you are correct. Liquor store gets robbed, they got a good surveillance system. You go in, you yank that picture, you run it through the system, and now you're at probable cause, possibly probable cause to do something. So yeah, it's a great tool. And we would never have 100 years ago passed a bill that said you can't put a book of mugshots in front of a victim of a robbery. We would have never done that.
Well, so thank you for that. That's helpful. Now looking at page 10 of the bill, down to the bottom, it says a unit may not use a facial recognition service to engage in ongoing surveillance unless, and it goes on. So in my hypothetical, which you agreed with, you've got these security cameras all over the place and they're running, I guess, constantly. In my view, that would not be ongoing surveillance using a facial recognition system. Rather, you'd have the ongoing surveillance of the security cameras, which are not prohibited by law, and then you would isolate a moment or a group of images of individuals and use a facial recognition system. I'm not sure how that conduct fits into the phraseology of the bill, where it says a unit may not use a facial recognition service to engage in ongoing surveillance. Can you?
So
I
can help you with that. So as Senator Sydnor pointed out I pointed out in the exception that he made, at airports, seaports, and certain places like, say, the Super Bowl, they would be running the actual, and particularly airports, would be running the facial recognition to see if they can find the terrorists before they get on a plane. And what the bill is saying is we're not going to be able to do that in Towsontown Mall, just running the surveillance, the facial recognition off the surveillance system. The way it's designed is we're going to use it like you described, and that is once the crime has been committed, then we can utilize all the surveillance video and other ways of capturing pictures to then run that picture through the surveillance, through the facial recognition. So that's the distinction.
And let me finish with one final question. On the next page, it talks about how you can't use this unless a warrant is obtained and showing that there is probable cause for the belief that an individual has committed or about to commit an offense. So if you have surveillance film of a part of a mall, and then inside one of the stores in the mall, someone smashes a counter and rips out some jewelry and takes off with them, all you're going to have is surveillance photographs of people in the more public areas of the mall, and you're not going to have any probable cause with respect to an individual. Wouldn't you want to have the right to examine the photos of 80 individuals within the 5 minutes contiguous to when the crime occurred, and then take those 80 photographs in and show them to the people in the store to see if they couldn't identify the person who smashed and grabbed the merchandise?
And you have focused in on one very important part on page 11, and that is I'm using the facial recognition technology to develop probable cause. And while I'm not going to take those 80 surveillance videos and put them into the system, I am going to narrow it down to the people who match the description that was seen by the clerk or captured in the video, and narrow it down to the individuals who are, males of a certain height. And then once I get it down to a certain group, that's when I use the facial recognition. But that's what I'm doing to develop probable cause. If I need probable cause to put it in the system, I'll never put anything in there.
You don't have the probable cause. Right.
Correct.
All right. Thank you so much for your answers to my questions.
You're welcome.
Okay, thank you. Any further questions from committee members? Seeing none, that ends the hearing on SB 587. Next, we have up SB 781. Senator Hayes, are you there?
Yes, I am.
Okay, go ahead and proceed, Senator Hayes.
All right, thank you so very much, Senator, excuse me, Senator Lee, and good afternoon, members of the Judicial Proceedings Committee. I'm Senator Antonio Hayes. For the record, this is my first and only time appearing before JPR this legislative session. Senate Bill 781, I'm pleased to be speaking with you today. It allows a buyer to mask their identity when entering a contract of sale for a single-family residential real property that is executed with the services of a real estate broker. This piece of legislation was brought to me by some professionals in that field, neither a real estate broker, professional, attorney, nor do I play one on television. But my panel today will be providing some more details about this legislation. The purpose of Senate Bill 781 is to protect people from discrimination in real estate transactions. It seeks to modernize the fair housing laws that are already in place. The removal of a buyer's name in a real estate transaction protects people against discrimination. A person's name can often be a representative of their culture, race, familiar status, and other ties to their backgrounds. This can lead to a bias in a real estate system. We have a chance to correct this piece of history, especially with the modern access to social media and other things. It's a lot easier to access individuals' identity. Housing is an important step to the social mobility, and all people deserve to be treated fairly during the process of real estate transactions. Senate Bill 781 is a step in the right direction. I would suggest to this committee and that there may need to be some amendments, and some of those that are speak will address those things. But the bottom line purpose and spirit of this bill is to make sure that individuals have a fair right and access to the purchase of real estate properties in the state of Maryland without the fear of discrimination. And so with that, members of Judicial Proceedings Committee, I urge a favorable report for Senate Bill 781.
Thank you, Senator Hayes. Now, I believe your first witness is Julia Martin Frazier. Can you identify yourself and your organization and proceed ahead?
Excuse me, I think the next person to give testimony is Kimberly Kepness. Thank you.
Is that your witness, Senator Hayes?
Yes,
Kimberly?
Kimberly.
Okay, I didn't know she was going first. Excuse me.
I think it, yeah.
That's
Go
okay.
ahead, proceed.
Thank you. My apology. Thank you, Senator Hayes, Madam Chairwoman, and honorable members of the Judicial Proceedings Committee. We understand that the idea of withholding the buyer's name from a contract of sale is going to be uncomfortable for sellers. We all want to know who is buying our home. It's natural to want to pass a house to someone that we like or someone that we have a good feeling about. And it is in the process, it may lead to a fair housing violation, whether that is implicit or otherwise, if we choose between or deny buyers along these lines. And in order to protect sellers from making a decision that could violate fair housing, we believe it's necessary to withhold buyers' names from the contract of sale. And so we have submitted Senate Bill 781 with recent modifications, and we believe when approved, buyers will continue to sign purchase offers as they do today. We'll continue to provide pre-approval letters and verifications of financial capacity to sellers. The form changes we have proposed for our contract documents to the Maryland Realtors could allow the buyer field on page 1 of the contract of sale to be moved to the last page of the contract of sale. Once an agreement is reached, the buyer's name would then be inserted at this new location along with the date of our contract acceptance. This change removes the need for any client A or client B alternative identity for the buyer. And that change can also provide a procedure that supports the buyer's interest to have their identity withheld during the negotiation, and the sellers, brokers, and third-party lender and title companies' interest to have the parties' names on the ratified contract of sale. We've made these recommendations to the Maryland Realtors. We've also made recommendations to revise the legislation to exclude entities, to support the Attorney General's caution to require uniform application for all residential contracts of sale to ensure all buyers' names are withheld, and to review any need for potential identity or fraud contingencies, which could protect the seller in the event a buyer fails to provide a material identity disclosure prior to contract acceptance. We are looking forward to working with you, Maryland Realtors, the Attorney General, and others to improve on this legislation, its practical application, and to protect buyers and sellers from decisions in housing which violate fair housing. Thank you.
Thank you. Our next witness, would that be Julia Martin Frazier? Is that correct?
I believe it was Rodney
Or
Dotson.
is that
Rodney Dotson.
Okay.
Yes, ma'am.
Mr. Dotson, go right ahead. Proceed.
Thank you. Thank you. Thank you to Senator Hayes Thank you, honorable members of the committee and Madam Chair. My name is Rodney Dodson. I am a realtor at Monument Sotheby's International Realty here in Baltimore. A graduate of Morgan State University, husband, father, lifelong resident of Baltimore City, and one of the original drafters of the bill. Today, we introduced Bill SB 781, the removal of the buyer's name from the residential contract to sale. When we are born, we're given a name that reflects joy, heritage, and a transcending hope for a life to come. Our families beam with pride as their name and legacy will continue on. Unfortunately, as we grow, we understand the cruel reality that we can be prejudged by our given name. In these moments, it's no more joy, but more honestly, it's a deep search for acceptance. Many believe Maryland laid the grounds for racial discrimination pertaining to real estate with Baltimore City's Council's passing of the Residential Segregation Bill of 1910. This was the first bill of its kind in the United States to apply government legislation to achieve systematic citywide race separation. It can further be applied that many other states adopted redlining legislating measures based on the practices which started in Maryland. Our claim today is that every buyer who submits a contract to purchase residential real estate in the state of Maryland should be given a fair chance to purchase. When a seller receives an initial contract to purchase the real estate with a buyer's name on it, this can open the door for a biased response. In some cases, even a rejection simply based on a buyer's name. Of the pending legal case in the U.S. District Court in Massachusetts of Clinton Brown versus Hardick was reported in the December 2020 issue of the National Association of Realtors Fair Housing Corner, where the plaintiffs, Clinton Brown, filed a lawsuit alleging violations of fair housing. Quote, although the parties had verbally agreed to the terms of the sale, when the Hardicks received a signed purchase agreement from the Browns and noticed Miss Clinton Brown's first name was Ebony, they asked their realtor, was Miss Clinton Brown Black? I'll wrap up by saying I want to introduce Miss Julia Frazier, a co-worker at Monument Sotheby's, who has a similar account of this current proceeding that is currently going on in Massachusetts.
Thank you, Mr. Dodson, for your testimony. Go ahead, Ms. Frazier.
And thank you, Senator Hayes, honorable members of the Judicial Proceedings Committee. My name is Julia Martin Frazier, and thank you for the opportunity to speak in support of Senate Bill 781 as a licensed Maryland realtor. I believe my personal experience, which I'm about to tell you, is very similar to the federal case aforementioned by my colleague, Rodney Dodson, demonstrating that discrimination based solely upon a person's name is not an unusual or isolated occurrence, and is happening with some regularity in the real estate marketplace. The topic of fair housing and discrimination is of paramount importance in our industry. It's a topic of great emphasis in our licensing and continuing education. So I was greatly frustrated when faced with a situation of suspected discrimination to see firsthand how impossible it was to assure my buyer clients this was not the case. Last October, my client submitted an offer on a house of their choosing. In speaking with the listing agent, I learned that our offer would be one of three. My client's offer, although we were told was the strongest, did not get accepted. When I asked the agent repeatedly why the seller chose what we had been told was a less favorable offer and no answer came, the silence was deafening. Armed with no answers, I had to deliver the news to my clients, Chukwu Ebuka Umuna, Chukwu Nanso Umuna, and Cynthia Torres Delgado, that although they came in stronger, another offer was chosen over theirs. I do not know what conversations occurred with the seller and their agent. What I do know is that my clients wanted and deserved a fair explanation, and I had none to give. Had my clients not been identified in their offer, I could have assured them at least there was no bias at work in the seller's choosing of a weaker offer over theirs based on their names. In summary, I share a quote from the Greater Baltimore Cooperative Realtors website, quote, "To be silent is to be complicit. We recognize that we cannot solve a systemic problem overnight, but we are committed to making progress and to working with our elected leaders to create legislation addressing the end of this abuse and solving this systemic racism," unquote. I believe this bill presents such an opportunity. Please consider making this a reality for all buyers in the state of Maryland who deserve to enter the housing market on a fair and level playing field. Thank you.
Thank you. Now we'll turn to the unfavorable witnesses. First, Rory Murray. Please proceed if you're.
Can you hear me? Great. Madam Chair, Vice Chair, members of the committee, my name is Rory Murray here on behalf of the Maryland DC Credit Union Association. We understand and support the intent of the bill. We just are opposed to the language as drafted. We understand that the goal here is to limit any possible discrimination in the buying process. However, the shielding of the name from the contract itself is obviously problematic. One, from a contract law perspective, contracts have to identify who the buyer is. There are various ways in which a buyer can buy anonymously through a nominee or an LLC, but under Maryland law and the way that this bill looks, a broker, a real estate agent or broker is not allowed to act outside of what is called ministerial acts, which you are all probably familiar with, on behalf of their clients. Contracting, being the point of contact for a contract between the broker and the seller on behalf of a client, which would have a separate contract as contemplated in the language of this bill, it just goes far beyond what a ministerial act is, and that just brings up obviously legality and capacity issues for us. So as we said earlier, we're happy to continue to work with the sponsors to figure out ways to possibly, although it wouldn't be it'd be credit unions would be agnostic to it, but if they want to change the disclosures between buyer's agents and seller's agents or what have you in the bid and offer process, we take no position on that. But as for the contracts, obviously enforceability and legality come first in our minds. So this is the first I've heard about any changes made to the bill. They seem to be in line with the concerns we raised, and we're obviously very happy to continue to work with everybody. I think we've got the same general goal in mind, just need to clean up the language. So thank you.
Thank you, Mr. Murray. Now our next witness is Mr. William Castelli. Could you please proceed?
Yes, thank you, Madam Chair and members of the committee. Bill Castelli on behalf of the Maryland Association of Realtors. And like the previous speaker, we also agree that the intent and goal of the bill, which is to reduce discrimination in the home buying process, is an important one. We would like to continue to work with the parties to find a solution that would meet contract law to ensure that the contracts are enforceable. The proponents of the bill did forward us some language. We are looking at our initial, response to the language is that we need a couple more attorneys to look at it. I mean, right now, when we're looking at the real estate contract, typically what happens in a normal transaction is the buyer makes the offer, the seller would then accept the offer, sign. You would have mutual meeting of the minds, contract is done and ready to go. The process that they are talking about with some of the amendments, we want to make sure it doesn't flip the process where the buyer doesn't sign and thus you don't really have an offer, you have an intent to purchase. And then the seller would then make the offer, and then the buyer, if we don't do it correctly, ends up being the person that either accepts the offer or not. Now, some people might say, well, why does that matter? Who makes the offer and who makes the accepts the offer? And particularly in strong real estate markets like we have right now, if the buyer is put in the position of being able to say no to the offers, we do believe that many buyers would end up making lots of contract offers because they're not certainly obligated to that, any of those offers once the seller decides that they would like to accept it or not. And that not only ties up the process for the seller, but it also ties it up for other buyers that might be more interested in those properties too. So we think, one of the things that we had talked about with some of the proponents too was whether there might be a technological solution to this. We know that obviously there are ways to do electronic contracts where it would be more easily through technology to mask maybe signatures, and certainly interested in exploring that some more too. But again, we'll take a look at the language and have forwarded it to some of our contract folks. But we are definitely concerned about enforceability right now.
Okay, thank you very much. I assume that all stakeholders are working together with the Senator Hayes to come to some resolution. Senator Hayes, I guess you're working with all stakeholders here. Sandy, unmute Senator Hayes, please.
Okay, thank you, Madam Chair. Finally, I'm sorry about that, to have you on such a hold for so long. But no, definitely the intent is to continue to work with all the stakeholders and see where minds can meet in the middle. And I appreciate you urging us to do so.
Okay, thank you, Senator Hayes. Senator West, you have a question. Proceed, please.
Oh, yes, I do. Thank you very much. It's great to see Senator Hayes. And it's a shame, Senator, that this is the only time we're going to see you this year.
I know. I'm so heartbroken.
Well, we are too. Senator Hayes and I both served together on HGO in the last term, so we're good friends. So because we're good friends, I'm not going to subject you to tough questioning, but merely to point out to you that the Consumer Protection Division of the Office of the Attorney General has put a letter in the file with a number of concerns. So I'm hoping that before we would reach this bill in a voting session, you can get us a written response to the concerns voiced by the Attorney General so that we can consider them.
Absolutely, happy to do so.
Sure, and that's my question. Good to have you with us. Sorry we won't see you again.
It's a pleasure always, Senator West, and everyone here at JPR.
Thank you, Senator Hayes.
Absolutely.
Ends the hearing on SB 781. Thank you.
All right, thank you.
We'll go to see you.
Oh, Senator Carter seemed to be trying to be acknowledged.
Oh, I'm sorry, Senator Carter.
I thought she was speaking at first.
Senator Carter, did you have a question? Did you want to ask Senator Hayes anything? Okay, great. Thank you, Senator Hayes again.
Thank you. See, I think my brown hand didn't show up as brightly as the yellow hand. But I have a couple of questions, so sorry to belabor the hearing. First, I'm going to start off with a comment that I sat here as if life weren't hard enough, feeling absolutely depressed that in 2021, our society is deemed so racist that we can't even have the names of people put on a contract for sale because we anticipate discrimination. I want to start off with that. It's really, it's horrible. It's horrible that we're at that point. I'm not sure if this is a solution, but I'm going to trust the stakeholders to try to work whatever out has to be worked out. A couple of questions. One, Clinton and Eberty Brown, did the buyer renege? Did the buyer retract on that contract when they found out the name, or they just asked the question?
Ronnie.
Who would like to answer that question? Okay, Roy, Murray, and also Kimberly. Okay, everybody won. Sandy, could you unmute Roy Murray first, and then Kimberly, and then
seller. If I said buyer, I meant, did the seller, once the seller found out that the potential purchasers were Black, did the seller choose not to sell to them?
That's right. It was the very end of the bid and offering process. They had gotten to the last stage of it. It was here, sign the contract. And that is when the seller looked at the name, asked, is this a Black person, was told yes, and said, I'm not selling.
Thank you. I was just curious because I didn't feel like I heard the whole end of the story. The second thing I wanted to mention is that some years ago when I sold my first home, my very beautiful first home that I was extremely proud of, I remember being cautioned by the realtor to remove any art or anything that could indicate to the potential buyers that I was Black because we didn't want to fend off any, we wanted to make sure that all potential buyers were interested and not going to be turned off because the homeowner was Black. So, I mean, I did as they said. I remember I moved everything. So it was just like a very, neutral look in the place and no indication of ethnicity or race at all. But so my question is, given that situation, I mean, why would we limit it to just potentially racist sellers? Like, couldn't there be racist buyers that would not want to buy from a seller because of ethnicity or race or some other prejudice?
Kimberly, you want to give a shot at that?
Yeah, what I would say is that, because primarily we have sellers who are making decisions in housing, and those decisions are based on offers from purchasers, that what we're experiencing in our marketplace is factors that don't relate to price and terms that are being utilized to deny buyers the opportunity to purchase. And while I absolutely appreciate, and that's very upsetting and disappointing, that a recommendation would be made to change the home to make sure that it appeals to everyone, if there's an opportunity for us to address that, we would like to as well. The bill has been focused to try to support sellers by helping them in the implicit bias that we have experienced that stand in the way of sellers focusing on price and term. And we're excited to be able to work with Maryland Realtors, happy to work with all of the other stakeholders. We do want to make sure that it's clear that there was no time in this bill, in the current reading of the bill and the modifications, that we recommended that the purchasers not sign the full offer to purchase. That absolutely is necessary in order for the parties to be able to negotiate with one another. I just wanted to make that clarification. Thank you.
I don't want to belabor this because I have a couple more questions. One, the next one is more of a maybe a comment as well, but another concern I have is that I actually might not want to purchase a house from someone that's racist. So I might not actually want to spend my money to buy a home to financially benefit a seller that would not want me to buy the home if the seller knew that I was Black. So that's another concern I have in the potential process, that, in removing the name, then I don't get to know. Like, I would like to know. I'd probably not want to purchase that home because I figure I could find another house from someone else that wouldn't mind having me spend my money to purchase their home and where they financially benefit. You see what I'm saying?
Yeah.
No, totally.
Dodson, did you want to answer that question, Mr. Dodson?
Yep.
Go ahead. Sandy, can you unmute Mr. Dodson? Sandy, could you unmute?
Hi,
She's working on
thank
it.
you. Thank you, Senator Carter, for your input. Yes, and respectfully, I do understand your point, your perspective on that. But personally, as a realtor, I show homes and present offers on a daily basis, and I do have buyers that have questions after they have submitted offers, whether it be in Owings Mills, whether it be in different parts of the state, that they have questions, and they look to me like, didn't we present a strong offer? And sometimes, they physically asked me, was it because I was Black? Now, they wanted the house, they were comfortable with the area, but I really I can't really, tell them whether it was because you were Black or not. And that's a gray area that I think this bill wants to guard against. We want to, put the protection back to the buyers in such a way, a groundbreaking way in Maryland, that it can address discrimination or the possibility, implicit or implied.
Thank you. And finally, is this modeled off of legislation that already exists somewhere else? Or is this a first impression type of law?
Senator,
Not that,
address that issue too.
not that we know of. We're doing our due diligence for research in America, but we do not know of where this exists in the United States.
So I said finally, but not really finally. So finally, this is one aspect of that process of purchasing real estate. But we know from data that's come out over the last more than a decade, especially with the foreclosure crisis that happened in 2007, 2008, that Black people were categorically discriminated against in the housing industry, that even Black people that had good credit ratings or those on par with their white counterparts were often given horrifically bad mortgages, higher interest rates. And so I don't know, I know this is only one step in trying to do that, but what can we do to ensure fairness in the process across the board to make sure that that discrimination in the pricing and in the interest rate is also addressed, and it's not elevated because of a person's race, gender identity, ethnicity, or any other reason that we would not want someone to be discriminated against?
No, Senator Carter, I think there's a host of bills to try to identify the discrepancies, especially as it relates to discrimination, whether it be appraisals and other things. I think a part of, we should know that a part of Speaker Jones' Black agenda, she has several bills to address these disparities and recognize the history of, real estate here in Maryland and in the United States. And so we saw this as just a piece of it, but you're absolutely correct. This isn't a panacea to all of the issues as it relates to discrimination around this issue. And so, it looked like Julia had something else to add, Madam Chair.
Thank you very much. And yes, well said, Senator Hayes. In answer to your previous concern, Senator Carter, I wish my clients were here because I'd like to take the liberty to say what I think they would say with regards to their experience. I think they were happy enough to not, in the end, buy that house, knowing that it was possibly being sold by someone with racist beliefs. But they are still filing a complaint, and they still felt that their fair housing rights were violated. So, whether or not they would like to move ahead with buying that particular house, absolutely a great point. They probably don't, and realize that, maybe in the end, the house they ended up with was for the best. However, they do still feel very strongly that they were discriminated against. And that's the kind of thing, it's our job to protect, these protected classes and make sure that these violations don't continue. That's our intent. Thank you.
Thank you. And thank you, Senator Hayes, for bringing the bill.
Absolutely. Thank you, Senator Carter, and thank you, Madam Chair. Fantastic. Thank you.
Thank you, Senator Hayes.
All right.
Okay, that ends the hearing on this bill, SB 781. Next, we'll go to the next bill, 28. Senator Riley, you're on. Go ahead. Proceed.
Thank you very much, Madam Chair. Ed Riley, District 33, Anne Arundel County. I'm here to present Senate Bill 628, the title of which is Landlord and Tenant Establishment of Rent Escrow Accounts Time Limit. So the issue before us is when there is a dispute between a tenant and a landlord over health conditions, condition of the house, etc., often they go to court. And the judge would rule that the money that was due for rent would be put in an escrow account, generally with the court, and that they would send an inspector out to determine the validity of the issue before them and to make sure that a house is safe, hygienic, functional. Well, under the current law, the tenant has 5 days to fund the escrow account at the courthouse or an approved intermediary that the court may determine. This is used oftentimes as a delaying tactic because the tenant never intended to pay the rent. But if you have a health issue, you know that the court's going to expect the money to be put into an escrow account. You should go to court with the expectation that a deposit should be made. So the bill changes the 5-day time limit to the term on the day the court entered the order. So that if in front of the judge says, you're absolutely right, we're not going to require you to pay the landlord the rent, put it in our escrow account. Once we determine if there is a violation that the landlord has to fix, he'll fix it. If there is no violation, then the money goes from the escrow account to the landlord. The current law of 5 days is a stalling tactic. We're trying to make sure that the tenant is held accountable and the landlord has an appropriate recourse if it's just a delaying tactic. So effective date of the bill would be October 1, 2021. Have one that I know of, one letter of support from the Maryland Multi-Housing Association. The second one was from the Maryland Board of Realtors. One letter of opposition from the Maryland Judicial Conference. And their comment is it takes away judicial discretion. But if we have a clear and firm understanding of what the process is, then there shouldn't be any discussion about discretion. If you have a complaint and it's not about whether or not you should pay the rent because you can't afford it or you don't have it, if it's a matter of health and safety, then you should be ready to make a deposit in an escrow account. For these reasons, I'd ask for a favorable report on Senate Bill 628, and I have one witness, Mr. John Grosso.
Okay, Mr. Grosso, please proceed. I think you have 3 witnesses, I believe.
I only have one. Yeah, I only have one.
Okay, Mr. Grosso, please proceed ahead with your testimony. Vicky, is Mr. Grosso unmuted? I think he is. Go ahead, Mr. Grosso. Proceed with your testimony. There might be a connection problem, a technical issue.
Okay, well, go ahead with the unfavorable. I'll see if I can get them to say hi.
Do you, should we let the other witnesses go forward, or would you prefer?
That'll be fine. No.
Okay. Is William Castelli here again? Go ahead.
Yeah, yes, thank you, Madam Chair, members of the committee, Bill Castelli with the Maryland Realtors. And we are in support of the legislation. We think the legislation makes sense. Oftentimes, when a rent escrow is called for by the court and in order to investigate whether there might be a problem with the apartment, there might be a condition that needs to be fixed and the rent needs to be set aside until that condition is fixed. Oftentimes, because of that 5-day, that rent never gets deposited into the rent escrow. And so, because of the way these trials and actions are scheduled, all the parties have notice at least 5 to 10 days that this is going to happen. Oftentimes, given delays in some of the county courts, it might be next month. So the parties have notice about the fact that they're coming to court. They have notice, they know whether they're going to make a claim for a rent escrow. So asking them to carry the rent with them or a check with them at the time to deposit, we think makes sense and would encourage a favorable report.
Okay, thank you for your testimony. Now we have a favorable witness, Catherine Howard. Please proceed ahead.
I think John's calling again.
Yes, Madam Chair, this is Kat. Can you hear me now?
Yes.
Great, thank you. Yes, my name is Kathy Howard. I am General Counsel for a regional management company here in Baltimore City and Baltimore County. And we are in favor of this bill. This bill does the concept that the bill that as we've been discussing that would require prompt escrowing of funds in a rent escrow case is a very good one. It is very important that the balance between in the statute between the need to get repairs made and the and have rent be able to be paid after those repairs are made. It requires that rent be escrowed. Be prepared, the tenant be prepared to put the rent in escrow, and that they do that promptly. The other part of this bill, it also is drawn to the jury trial sections of the real property article, at least as I read it, and those parts of the statute also require that rent or bond be posted if there is an appeal by the tenant or the landlord by the tenant in those kinds of cases: rent escrow, failure to pay rent, breach of lease, and tenant holding over. So that it is imperative that if they're going to take an appeal, that they do put their rent in escrow immediately, so that a bond can be posted and the appeal can timely go forward. So in both of those instances, rent escrow, as well as where there is a jury trial prayed from a district court case, both of those situations demand, I think, in the interests of time, justice, and practicality, that rent be put in escrow immediately and not within a 5-day period. And we offer a favorable and ask for a favorable report.
Okay, thank you.
Madam Chair, we have Mr. Grasso, and John, can you?
Okay, great. Go ahead, Mr. Grasso. Can you proceed with your testimony?
Hold on. No, he's not on speaker. Hold on. Okay. We're gonna wire him in. I see his lovely face somewhere.
Okay. Whatever works.
You're all set.
All right, go ahead.
All right. I want to thank everybody for getting this opportunity to talk about this piece of legislation. The issue behind this piece of legislation is dealing with rent escrows. And basically what happens is if you have a tenant that is dissatisfied by the performance of a landlord, they have a tendency of not wanting to pay the landlord. It also can be the other avenue where the landlord turns around and doesn't want to make repairs on the property because the landlord is not getting paid and also may not have the funds to be able to make the repairs. Thus, formed many moons ago was the escrow account. And the escrow account was to perform a mediation between landlord's disputes and a tenant's dispute. And so what would basically happen is when a landlord would file a failure to pay rent, you would go before the judge, and then the tenant would bring up an argument and say, I'm not paying the rent because every time I pay the rent, the landlord is not fixing anything. And then on top of that, the landlord turns around and gets up and says, no, that's not true. See, I do fix everything, but they don't want to pay. They keep breaking everything and they don't want to pay me. So they form the escrow account. So a judge will turn around here on both sides of this case, and what will wind up happening is, in general, they will postpone that case for 2 weeks. At that point, during that 2 weeks, they will send a housing inspector out to the property of question, and it is up to the tenant to make arrangement with the housing inspector or to let the housing inspector come in and look at these concerns that supposedly is happening on this property. I've seen it way too many times in court where the tenant turns around and says, I've got all these issues, and then 2 weeks later, the court wastes its time and the city wastes its time sending out an inspector, and then the tenant doesn't let him in. And then on the other flip side, you may turn around and have a tenant that says, okay, I did let the person in, but when the hearing shows up, that 2 week schedule out, now you're in front of the judge, there's no tenant. And the landlord shows up. And so the purpose of this bill is pretty much cut bait or fish is pretty much the word I'd like to use here. If a tenant has a problem and a landlord has a problem, then this bill is asking the legislation to tell the tenants, fund the escrow account within 5 days of the initial hearing. So when you go to a failure to pay rent, 5 days later is within 5 days. If truly the tenant has a problem with this landlord, should take their rent and put it in rent escrow so that the landlord can feel comfortable and call up and say, yes, the tenant is really serious about this. I'm going to fix the problems that need to be done. And also the landlord can be secured that the money is actual there. What is happening way too many times is that the tenant is using the courtesy of the court or playing the court system to buy more time for not paying rent. In fact of the matter is that many times they're being disingenuous in their claims about having problems with the property when they really don't, knowing that it's going to take at least 2 weeks more before the inspector shows up, knowing that they can turn around and delay an inspector from coming in to see if there actually is some problems behind this. So once again, circling the wagon, this piece of legislation is pretty much to say, okay, if you got a problem and you've got your rent, and this isn't a game to escape paying for rent or delaying an eviction, put the money in rent escrow. And then once that money's in escrow, then everybody's on board. Then the inspector winds up getting into the house. If there's issues, the landlord says, hey, I got to fix these issues. And then after all that's taken care of, then there's another court hearing behind that. And then the judge decides, is there a reduction in rent that should be given to the tenant because the inconveniences or problems they had into it? Or no, there isn't any problems here, that the landlord should still get their full amount of rent money because they were never notified the tenant in a timely manner. But, you know, that's the procedure that normally would happen. So we just want to make sure that tenants being genuine or being truthful and actually having an issue and they really have the rent, then you need to fund the escrow account within 5 days of your failure to pay rent. And that's what the legislation does.
Right. Current law says 5 days. The suggested legislation is on the day the court order is entered, that's when the deposit gets put into the escrow account. Madam Chair, that's our testimony. John Grasso, you may recognize his name, was a former county councilman for Anne Arundel County.
Okay, and he's written testimony as well. Is that correct?
Yes.
Okay, thank you, Senator Riley. We have a question from Senator Hedelman. Go ahead, Senator Hedelman. Please proceed.
Thank you very much, Madam Chair. I guess I am wondering why we would want tenants showing up, standing around in court for hours with lots of cash in their pockets, and what the urgency is of that particular moment is one question. And the second is, I don't see anything in here. This is only with regard to jury trials. And I don't see anything in here about the conditions of disrepair escrow, which is a different section of the code. So I'm just curious about the distinction
we're
between
focused
those.
on the disrepair code. So if it needs to be adjusted, we need to do that.
Okay, so that was your intention?
Yes. The intention is that the tenant and the landlord have a discrepancy over the condition of the building. Landlord says it's a good shape. The tenant says something needs to be done.
Okay, so I think
So Senator Hedelman, thank you for picking that up. Great catch. But again, what happens is after the order is entered today and the judge says the tenant has 5 days to fund it, if they don't come back, then the tenant has to come back, or the landlord has to come back and kind of enforce a non-payment issue. This is, and I thank the chairwoman for this idea, or maybe it was you, someone standing around with a pocket full of cash. Generally, these transitions are done by check, certified check. Very few people carry cash these days.
Okay, and I guess I still am not really clear about why we shouldn't leave this up to judicial discretion.
Because it creates the opportunity for tenants who are using the system to their advantage to delay another month or so before they're held accountable for non-payment of rent.
All right, thank you.
You're very welcome. Thank you for your observations.
Any further questions from committee members? Seeing none, that ends the hearing on SB 628. Thank you, Senator Riley.
Thank you, Madam Chair.
All right, now we'll go on to SB 724. Senator Carter, you're up. Go ahead, proceed.
Thank you. Thank you. Hopefully I see my panel being let in. Madam Chair, I just want to say you're doing a wonderful job acting as acting chair today. I really appreciate you. So, Madam Chair and members of the committee, the goal of this bill is to provide relief to homeowners that have been struggling to keep up with mortgage payments during the ongoing emergency caused by the COVID-19 pandemic. There are many facets of relief contained in this bill, but the primary ones are extending the foreclosure moratorium and requiring mortgage servicers to grant forbearances to homeowners facing serious financial hardship as a result of the state of emergency. In addition to foreclosure prevention and forbearance protection, this bill establishes that once the period of forbearance ends, the default repayment method is to add to the missed payments to the end of the loan. This prevents homeowners from being forced to pay exorbitant fees or lump sums as soon as the forbearance expires to make up for what they have missed. The bill also prevents mortgage servicers from assessing late fees to homeowners in forbearance during the state of emergency. The bill also prevents mortgage servicers from publishing negative credit information about homeowners relating to mortgage payment forbearance as a result of the state of emergency. This will prevent mortgage servicers from threatening such action over homeowners in order to pressure them to pay when they're already suffering and in forbearance. The final aspect of this bill is to create a private right of action for homeowners to sue mortgage servicers if they do not comply with this bill. This would create an additional incentive for mortgage servicers to comply with the law and actually be able to provide relief to homeowners. I believe that each part of this bill is significant and will truly help people stay in their homes despite the negative financial impact that COVID-19 is having on so many Maryland residents. Just in January, a Census Bureau survey showed that 21% of all Maryland homeowners thought they would face foreclosure within 2 months, while only 1% thought that their payments would be deferred. This highlights the need for greater notice and notification to all homeowners from all mortgage servicers about forbearance opportunities. With so much uncertainty for citizens regarding their education, employment, health, savings, housing, security should not be another major concern weighing on our citizens' shoulders. And so for these reasons, I would urge a favorable report. Thank you.
Thank you, Senator Carter. I believe your witness is Marceline White. You want to go and proceed ahead?
Yes, thank you so much, Chair Lee, members of the committee. My name is Marceline White, and I'm the Executive Director of the Maryland Consumer Rights Coalition, MCRC. And MCRC advances economic rights and financial inclusion through research, education, advocacy, and direct service. I'm here in strong support of Senate Bill 724, and I want to thank Senator Carter for sponsoring this legislation. And I'm here today to ask for a favorable report. As Senator Carter explained, this bill provides and extends important measures to protect homeowners during this unprecedented crisis. In addition, these protections include stating that a mortgage servicer may not commence nor complete a foreclosure action during the state of emergency, allowing homeowners to seek forbearance, and after the forbearance is granted and the state of emergency ends, the homeowner may request, but it doesn't require, may request additional mediation. And it sets in terms for denying that request. And finally, it clarifies important protections and safeguards of the mortgage and clarifies when servicers can and can't require what they can and can't require regarding mortgage payments and loans. I want to clarify what the bill does not do, because you may hear something from the opposition. It does not conflict with state or national executive orders, laws, or regulations. It does not create undue burdensome requirements for servicers. And there is similar legislation that has been implemented in California, and servicers have been able to comply readily with that legislation. Now, let me tell you why this legislation is needed. Despite what you may hear from the opposition, the bill is urgently needed. This committee has done so much good work in the interim and this session, protecting and looking at evictions and extending protections for renters and addressing homeownership. This builds on the good work that has already taken place. In fact, this creates an opportunity to get ahead and be proactive before the looming foreclosure crisis. Yesterday, the Consumer Financial Protection Bureau released a new report on housing insecurity since the start of the pandemic. And in this report released yesterday, they found the number of homeowners nationally behind on their mortgage has doubled since the beginning of the pandemic. And the more homeowners are behind on their mortgage now than at any time since 2010, which was the peak of the Great Recession. They also found that 2.1 million homeowners are more than 90 days behind on their payments, which is a key benchmark for being seriously delinquent. That's 5 times the number of families that were more than 90 days behind before the pandemic began. And Black and Hispanic homeowners are disproportionately affected and are further behind than white families in terms of these payments. So this is an economic rights issue. This is a racial equity issue. We know how the pandemic has affected Marylanders and the economic crisis has affected Marylanders throughout the state. So this is an important way to get ahead of the problem and take decisive action. You may hear that the foreclosure timeline is long in Maryland and there are already plenty of protections. And I will say that that's true. Many of you in the decided to extend the timeline for foreclosures so that homeowners had an opportunity to stay in their homes. And if they had to leave, they could do so with dignity. That was a decision the General Assembly made in 2009 to 2012. And this builds on those protections throughout the state of emergency. This builds on the good work, but allows us to be proactive and get ahead of the looming foreclosure crisis as indicated through the Consumer Financial Protections report yesterday, and provide sensible safeguards for protecting people from predatory payments and predatory mortgage loans or conditions. For all of these reasons, I ask for a favorable report. And again, thank you for your time. I'm happy to take questions.
Thank you, Ms. White. We're going to have questions right after all the witnesses have a chance to provide their testimony. Thank you, Ms. White, for your testimony. Our next witness is Beth Jacobson. Can you please proceed ahead?
Hello, and thank you for the opportunity to speak regarding my support of Senate Bill 724. My name is Beth Jacobson. I am a member of the NAACP and have been working and advocating for homeowners facing foreclosure since 2009. I blew the whistle on my former employer, Wells Fargo, due to its reverse redlining and predatory lending practices, which resulted in a $175 million settlement with DOJ. I testified as to the House version of this bill, and I'm here to debunk the comments stated by the opposition. It was stated that there hasn't been one foreclosure in the state of Maryland since the spring of 2020. That statement is false. On July 25th, the stay as to foreclosure sales was lifted, and since then there have been hundreds of foreclosure sales every week in every county in Maryland. The opposition has stated that Governor Hogan's executive order applies to all borrowers that are not covered under the federal rules. Again, false. Hogan's executive order does not provide any protections to borrowers that received a notice of intent to foreclose prior to April 3rd, 2020. The opposition had the audacity to state that the system is very favorable to anybody who doesn't want to pay their mortgage. Borrowers currently are unable to make their mortgage payments due to massive unemployment as a result of COVID-19. There is no strategic default by the borrower as suggested by the banking lobby. The opposition is urging you to let servicers handle the situation as they claim there is no incentive to foreclose and the false claim that the banks don't profit when they foreclose. Banks consistently deny borrowers for modification due to negative NPV, which means that the investor will make more money to foreclose than to modify the loan, despite the borrower's ability to qualify for a modification. It was stated that the rate of default in Maryland is 9%, as if 1 in every 10 households potentially facing foreclosure is an acceptable number. The CFPB provided a report yesterday stating that in 2020, Borrowers who have fallen behind at least 3 months on their mortgage has increased 250% and is now at a level not seen since the height of the Great Recession. In fact, delinquencies on FHA loans have now exceeded those as seen in the Great Recession. The facts. African Americans lost over 60% of their generational wealth in home ownership due to the Great Recession. African Americans are 70% more likely to be foreclosed upon. The percentage of home ownership by African Americans is now at the same level it was in 1968 when the Fair Housing Act was enacted. Black homeowners are 3 times more likely than white homeowners to be behind on their mortgage payments as of December 2020. Black Americans are experiencing more serious illness and death due to COVID-19 than white Americans. We are on track for a tsunami of foreclosures to be filed in 2022. And if we do not learn and correct the mistakes made during the Great Recession, there will be a greater loss of homes this time. Thank you.
Thank you so much for your testimony. Okay, our next witness is William Steinwedel. Are you there?
Yes, ma'am. Hi.
Okay, go ahead and proceed.
I would first like to thank Acting Senator Lee, Acting Chair Senator Lee, Senator Carter, and the Judicial Proceedings Committee for allowing me to testify. My name is William Steinwedel, and I am a staff attorney at the Foreclosure Legal Assistance Project for the Maryland Legal Aid Bureau, and we urge a favor report on Senate Bill 724. I've been in this area of the law for the last 9 years, at Legal Aid for 6 years and 2 months, and I have never seen this amount of job loss on the low income scale. I cannot think of a single client who I have not had to do a bankruptcy rework of their bankruptcy plan or assist them in attending a forbearance in this crisis. I have never seen it this bad. And unfortunately, and I really appreciate the forbearance programs that have been provided by both the state and the federal government, but if we do not come up with a long-term solution for this, it will be extraordinarily bad. And I'm warning you right now, it will be extraordinarily bad. And the reason is the forbearance, the modification protections that currently exist are extremely weak. There is no federal regulation or state regulation that requires the creation of a loan modification. It does not exist. It is nowhere in the statute. The only protections that exist is Regulation X, which says that if you submit a package 37 days or more before a scheduled foreclosure sale, they have to review it for all options. They do not have to give you anything. They do not have to restructure your loan. That is not a requirement, period. And I think the thought that the banks will sort of do this on their own, I'm not here to criticize the banks, but there is no evidence of that. And the only evidence we need is we only have to look back to the last crisis. Regulation X was an outgrowth of dual tracking, where the banks would basically tell the customer, yeah, you have a loan modification, just don't worry about it. And then they would set a foreclosure sale and not stop. And robo-signing, where they basically signed documents and didn't review them. And communication problems, which led to thank you, legislature, for passing a mediation requirement in Maryland. That was because of the lack of communication that existed between the foreclosure servicers and the customer. This law provides for protections in mediation. It prevents them from requiring a lump sum, and it requires mortgage companies to place defaults at the end of the loan. These are very important protections. If COVID was a war, which I truly believe it was, then this bill is the beginning of the Marshall Plan. This is the beginning of us coming back and making sure that the consequences of this crisis do not affect the lowest income people in this state. Thank you for a favorable report on Senate Bill 724.
Thank you so much for your testimony. I believe that is all the testimony for the favorable. Now we're going to go to the unfavorable. Is Robert Endon there? Can you please proceed?
I am. Thank you very much, Madam Chairman. Robert Endon on behalf of the Maryland Bankers Association. I did have a discussion with the sponsor yesterday about the bill and discussed with her some of our concerns. I would say that categorically, and we made this point in the briefing that we had. I think we had 2 briefings in front of your committee during the interim. Between what the federal government has done and between what the governor and the Commissioner of Financial Regulation has done, it preserves the ability of our regulators at the federal level and at the state level to deal with this situation as it changes. And that's critical, back in the summer when we were running at about 400 maybe cases a day, was certainly a much different world than the world we've seen in the last few months, where we were running at over 2,000, sometimes 3,000 cases a day. Now today, I think when I looked today, we had 600 cases yesterday. But this is a very volatile situation. And what the current ability of the federal government and of the governor to do is to deal with the situation as it evolves. I categorically reject the allegation that the federal government has not dealt with this. When the 80% of all mortgage loans that get made in this country are roughly 80% are federally backed mortgages. And both the Biden administration, the Federal Housing Finance Administration, Fannie Mae, Freddie Mac, FHA, have all pages and pages of regulations dealing with this issue. I would tell you most clearly that there is no benefit to any lender whatsoever in dealing with having a foreclosure. I would also tell you clearly and categorically it takes 530 days from the date of default to the date of ratification of a sale. We have the fourth slowest procedure in the country. But the one thing we've maintained is the ability to deal with this as it changes. No state in the country has enacted a statute anything remotely like this. What every other state has done and done what we've done, looked at what the federal government is doing, and as times change, issue executive orders. I have no idea when the governor's executive order will expire. When do you think it'll expire? He may change it. He may say, okay, I'm going to back up on this. I'm going to go forward with that, but it's not going to change. We think this bill is totally unnecessary. And my final comment is I would urge everyone to read the page-and-a-half comments of the Department of Labor's comments, in which they say that this bill's broad scope may undercut any intent to enact a foreclosure moratorium, and that those conflicts and uncertainty, along with the bill's imprecise language, will confuse consumers, the courts, mortgage servicers, and negatively impact the agency's ability to effectively and efficiently supervise mortgage servicers and protect consumers. Okay. We urge the committee in the strongest possible terms to give this bill an unfavorable report. Thank you.
Thank you for your testimony. Next witness, we have John Favazza. Can you proceed, please?
Thank you, Madam Chair. John Favazza. I'm with Manus Cannon and Associates. I'm here today on behalf of the Coalition of Maryland Mortgage Attorneys. The coalition's members are attorneys. They specialize in all issues related to real estate and real estate transactions, including expertise in the foreclosure process. Mr. Enton covered the issues with the legislation rather comprehensively. We agree, we share those concerns in light of the comprehensive actions taken at both the state and federal level to help homeowners during this pandemic. These emergency actions have been effective, and they're appropriately, provide federal and state agencies the flexibility to deal with what is a very fluid situation. Many members of the coalition have been involved in prior state reform efforts, notably the major reforms in 2008 and subsequent changes, to the 2008 measure. Scott Nadell, who's an attorney and is a member of our coalition, he's one of those experts. He's worked on these issues throughout his career. He's here today. He can more specifically address any questions you might have related to the legislation, the federal and state actions that have been taken related to the pandemic, as well as the foreclosure process generally. So with that, on behalf of the coalition, we respectfully request an unfavorable report. Thank you.
Okay, thank you. Our next witness is Scott Nadell. Can you please proceed?
Yes, good afternoon, Madam Chair, ladies and gentlemen of the committee. My name is Scott Nadell. I'm an attorney practicing in Maryland and in the District of Columbia, generally on real estate and creditor-related matters and involved in foreclosure work as well. I'm also the chair of the Foreclosure Committee of the Real Property section of the Maryland State Bar Association. I'm not here in that capacity today, but having served as the chair of the Foreclosure Committee since 2012, I'm very familiar with the current foreclosure laws and moratoria now in effect due to the pandemic. As my colleagues have just testified, and on the heels of the written materials distributed, I wish to echo that there is no need for the Senate Bill 724. There are already several executive orders from the governor in place, which started March 16th, 2020, April 3rd, 2020, October 16th, 2020, and December 17th, 2020. And just about 10 days ago, a new order from the Commissioner of Financial Regulation regarding the continuing inability to send and register new notices of intent to foreclose. There are no less than 8 administrative orders from Chief Judge Barbera of the Maryland Court of Appeals limiting foreclosures, which started June 3rd, 2020, August 11, 2020, October 2nd, November 12th, November 24th, December 22nd, and February 2nd, and most recently, February 16th, 2021. Various moratoria are also in place from the federal government and its agencies, which most recently, last week, extended the moratoria through June, all that address the issues of the pandemic. I agree with the Maryland mortgage bankers, Mr. Enton, and the other individuals who just testified, and there is no need to take legislative action as the matter is already being addressed. I therefore urge an unfavorable report on the Senate Bill 724. I'd be happy to take your questions, and thank you for your time.
Okay, thank you for your testimony. Our next witness is Chris Dipietro. Please proceed.
Madam Chair, members of the committee, my name is Chris Dipietro. I'm here on behalf of the Consumer Data Industry Association. CDIA is the National Trade Association for the Credit Reporting Agencies. Our issue with the bill is very specific and narrow. It's specifically, we have concern with section 7-608 on page 8, which basically would require the suppression of the reporting of data to credit reporting agencies. I think we had submitted written testimony to the committee, very detailed about why we believe one, suppression is not the way to go. But we also talk, because it actually has a worse outcome for consumers. But more importantly, the Federal CARES Act that Congress passed when the pandemic started addressed this issue specifically and said that lenders are to report and furnish this information to the CRAs, but they are to code it properly. That way, this information is dealt with properly and is not going to have the same repercussion if you did a suppression. On top of that, we believe FCRA as it stands preempts any state action on the prohibition of reporting data to a CRA. With that, we are opposed again to this specific provision within the bill. Thank you. Eric Ellman was supposed to be here to testify. Unfortunately, he had a conflict that came up this afternoon and will not be able to.
Has he submitted written testimony?
We have, the written testimonies was submitted under his name.
Okay, very good. Okay, seeing no more witnesses on the docket here, any questions from the committee members? Senator Carter, please proceed.
Thanks, Madam Chair. My question is for Bob Benton, and it's, I get the general tone of you and the other opponents is along the lines of all this is already being done. Why do we need to do anything else? The state and the feds have it covered. The governor and the feds have it covered. But my question is, what would be the harm in 2 specific aspects of the bill? The 2 aspects I'm concerned about are once these orders end and once these forbearance periods are over, that there is consistency throughout the state in making sure that homeowners are able to have fair payback plans post forbearance. And I'm thinking that if we just leave it up to the servicers, it'll be all over the place. If we just make it in the law, put in the law, that there has to be a payment plan to put these payments on the end of the loan or something along those lines that will help so that nothing slips through the cracks. And then my other question is regarding the notice. The concern is that servicers are doing their own notices, and many of them are giving notice. But the statistics I showed from the Census Bureau polling was that only 1% of the homeowners that believe they could be facing foreclosure understood that they had right now an ability to defer their payments through like a forbearance process. So what will be the harm in mandating the notice, and what will be the harm in mandating payment programs that work for people post forbearance? Those are my two questions.
Thank you very much for the question, Senator Carter. Let me say, first of all, that you have to take a look at what the federal authorities have done. Under the federal rules, and the governor by cross-reference has adopted those rules for non-federally related mortgages, in fact, gone beyond them. But under the federal rules, the holder of the mortgage, and this is the holder of the mortgage, whether there's an independent servicer or not, the bill applies to all mortgage holders, to anyone who holds a mortgage, must offer to the borrower at the end of a forbearance a range of options. And that range of options, and you talk about the differences, but every borrower is different. The mortgages are different, the borrowers are different. I heard from a constituent of a legislator the other day who told me that when he hadn't been paying his mortgage, when he reached out to his lender, what his lender urged him to do, and what he ended up doing, was refinancing his mortgage at a significantly lower rate than the original mortgage and extending it out for a longer period of time. That was the option that he chose. So what we do today is we have what we call a whole waterfall of options that all lenders today must offer to the borrower with the goal of keeping the borrower out of foreclosure. That's the goal. I would also tell you that as far as these percentages go, the information that's accurate is, and no one talked about the number of foreclosures that are occurring right now. And that's because when April the 3rd, notwithstanding the federal moratoria that were in place, which affected 80% of the market, and under the governor's order that he issued in April, when April the 3rd, under that order, the Commissioner of Financial Regulation was prohibited from accepting notices of intent to foreclose. So no, you can't file a foreclosure in the state of Maryland under Maryland law unless 45 days prior to the filing, you send a notice of intent to foreclose to the borrower, and you must file that with the Commissioner of Financial Regulation. Commissioner of Financial Regulation with the governor said that they would no longer accept notices of intent to foreclose. So contrary to what you heard, no new foreclosure cases have been filed in the state of Maryland for residential borrowers. If you take 45 days from April the 3rd, what's that take you out to May the 18th or something of 2020? And that would be the, if a notice of intent to foreclose was sent on April the 2nd, yes, that foreclosure could go through, provided the courts were open and the courts could hear it. When we look at this, all of the options are out there right now. They're mandated by federal law. They are flexible enough to deal with each borrower as the borrower comes to the lender. There's been no outcry. Statistically right now, our information is that the current foreclosure, the number of mortgages, percentage of mortgages that are in default in Maryland right now is roughly 9%. And has it gone up since COVID? Yes, it has. But of that 9%, over half are already in a forbearance plan. And with the most recent orders from the federal government and the governor, we went from 2 180-day forbearance periods, and now they bumped that out another 90 days. So you're talking about forbearance periods that are being granted to borrowers that are going to go out for a year and a quarter from, that'll be in place. And then it takes a year and a half to go through a foreclosure. And as part of that process, there is pre-file mediation, there is post-file mediation, there is a hearing in front of the Office of Administrative Hearings, OAH, and the court has the discretion to consider all defenses and not grant it. But what we find is that our lenders bend over backwards to work with the borrowers to avoid foreclosure. And the governor and the federal government is all over this. And to lock this 15-page bill into statute, as is pointed out by the Commissioner of Financial Regulation, which conflicts with federal law, despite what you heard, we think is just a serious mistake and would be bad for everyone in the state of Maryland. So that's why we think the bill should get an unfavorable report.
Thank you. I'm so happy to hear that, you know, these mortgage loan servicers are kinder and gentler than they once were. I think the issue, though, is that not all loans are federally backed. And I believe Ms. Jacobson actually pointed to specific numbers of foreclosure, which kind of refutes the idea that there's been no foreclosure filing and there's been no activity. There may not be a new filing, but that doesn't, I think, stave off ones that might already be in process. But that being said, thank you for answering the question. That's it. I don't have any further questions.
Are you satisfied with that? Okay, thank you, Senator Carter. No further questions. That is the end of the hearing for SB 724. Thank you, witnesses. Now we will turn to the next hearing, SB 832. Who is here on behalf? Is that you, Senator Ellis?
Yes,
Okay,
Arthur
great.
Ellis.
Okay, proceed ahead, Senator Ellis, with your SB 832.
Thank you, Madam Chair and members of the Judicial Proceedings Committee. I have a presentation. Thank you for learning that. I'm here to present Arthur Ellis, Senator representing District 28, Charles County. Our other senator in Charles County, Senator Jackson, member of your committee. I'd like to present this bill, Southern Maryland Multifamily Dwelling Registration Fees and Fines. Next slide, please. We're asked by the County Commissioners of Charles County to present this bill, which will authorize Charles County, which is the only code home rule county applicable to this bill, to allow the county commissioners to seek registration for all dwellings up for rent. Next slide, please. The purpose of this bill is to authorize the code home rule counties of the Southern Maryland class, which I mentioned Charles County is the one, to require the property owners to register the property with the county in order to lease it out to tenants. Our county has had problems with substandard properties being offered for rent to unfortunate low-income individuals, and before having had a power to intervene and to rectify this situation. Next slide, please. Why is this bill important? Well, it's important because registering a property for lease can afford the owner various protections under the law. For example, if an owner registers their property, tenants have more legal protection against forcible evictions, and property value is could be increased. Next slide, please. Of course, this bill will also benefit the tenants. If a lease is not registered, however, your claim to occupancy does not appear on the registered land title. So as the property you are leasing is sold, the new owner may not have to recognize or abide by the terms of the lease. Next slide, please. This bill also authorized the code home rule counties of Southern Maryland, which is Charles County, to impose a fine on the property owner who leases a dwelling that is not registered. Next slide, please. Further, owners with properly registered titles are more likely to engage the economy's workforce and boost productivity. This is because formal property markets encourage employment by increasing domestic stability and decreasing the likelihood of evictions in rural, poor, or even our urban area, particularly Waldorf. Next slide, please. And some references to some of this data we cited. Thank you. You can close out that slide, the presentation, please. With this presentation, like I said, the county commissioners of Charles County ask us to present this bill, to authorizing them to register properties put up for lease in the county of Charles, and to also charge a nominal fee for that registration paperwork. So with that, I present Senate Bill 832 and ask for your favorable recommendation on this bill.
Thank you, Senator Ellis. I just want to go to your favorable witness, Wayne Tyler. Is Wayne Tyler there?
Yeah, I think he expired his wait time and he had to get on another meeting. So I'm not sure if he came back on, but he contacted my office saying that he might have to drop off.
Well, has he submitted written testimony?
I think he did.
Okay. Is that sufficient for you?
Yes, ma'am.
Would you like to add anything else?
No, that's pretty much it. It's a pretty straightforward.
Okay. Well, thank you for your excellent presentation and testimony. We appreciate you coming before our committee. Committee members, are there any other questions of Senator Ellis? Speak now. Okay. Thank you, Senator Ellis.
Thank you, Madam Chair.
That ends the hearing on SB 832. Now we'll go to SB 892. Senator Augustine, you're up. Please proceed ahead.
Thank you, Chair Lee and members of the committee. Senator Malcolm Augustine here on behalf of Senate Bill 892, which asking for a favorable report, which will authorize the payment of a fee in lieu of a security deposit in a residential lease subject to certain requirements. Members of the committee, I just want to share with you why I was attracted to this bill. What this bill really does is it provides another opportunity for someone who is trying to get into a residential lease who doesn't necessarily have the security deposit. They don't have, like the first and the last amount. And what I learned in this process is that you do also, there is an additional option that is out there, not widely known or widely used, is that you could get a surety bond. It's really not too widely known as far as getting a surety bond as well as that, but that is an option that is out there for folks in order to provide some level of security when they are doing this. And then I also learned about this other option, which is a landlord-based insurance product, which ends up being a fee on that lowers that barrier to entry for people who are trying to get into a property. And what I thought about with it is, you think about the young kids who just coming out of college, stuff like that, and that's definitely a group of people who don't necessarily have, a security deposit in order to be able to get into this. But who I really thought about was someone who might well be in a domestic violence situation and they are stuck and they don't have the money to, they've got a job, they may or may not have an account in their name, but they have decent credit, but they don't have the money for a first and a last. And that's what made me think about this as an option, just simply an option that could be made available to a certain group of people. And that's really the essence of this bill. This bill does this. Now, this is an insurance product that is it's on the landlord side, like I mentioned, and it's already worked. I mean, it's already, it's functioning in Maryland. You'll hear from some of my panel about the fact that they already are doing this here in Maryland. But what this legislation aims to do is to really provide some certainty, some clarity, and some guide rails such that people are, so that it really clarifies what this option, and it really is, it's just simply an option, is all about. And so I'm going to turn it over now to the people who I'm working with on this piece of legislation, but I'm more than happy to answer any questions that anyone may have about what I think is an additional potential tool that reduces a barrier to entry for people in order for them to be able to get into a rental apartment. I'm asking for your favorable report, Bill 892. Thank you.
Okay, thank you, Senator Augustine. I believe your first witness is Chris Grimm of Leaselock. Please, Mr. Grimm, please proceed ahead with your testimony.
Thank you, Senator Smith. Senator Lee, members of the committee. Thank you for allowing me to testify in support of Senate Bill 892, legislation to help renters access housing by creating clarity around new security deposit alternatives. And thank you to Senator Augustine for introducing this important bill. Just like down payments are the biggest barrier to home ownership, security deposits are a major barrier for rental housing, particularly for first-time renters and people without savings. A 1-month security deposit in Maryland averages $1,700. With first and last month's rent, the average move-in cost exceeds $5,000. For a modest monthly premium, Leaselock insures property owners for up to $5,000 in lost rent and $500 in damages. To be clear, Leaselock insures property owners and not residents. But once protected by insurance, owners can then offer renters the option of waiving security deposit for a monthly fee that averages $25 a month. Nationwide, when given that option, 92% of renters choose the waiver. I want to emphasize that the deposit waiver fee is not an insurance premium. It is a payment in exchange for waiving the security deposit. The resident's benefit is significantly lower moving costs. This is made very clear in a separate lease addendum that the tenant signs that clearly states that the tenant is responsible for damages to the dwelling beyond normal wear and tear. Leaselock already insures more than 40 rental properties and more than 1,700 apartments in Maryland. However, we believe more properties will offer zero deposit rentals to more tenants if the law is clear that deposit waiver fees are permitted. Senate Bill 892 provides that clarity and ensures that when landlords offer zero deposit rentals, it will always be the renter's choice to pay a waiver fee or a security deposit. Leaselock is offered in the full spirit of Maryland's fair housing and anti-discrimination laws. Leaselock underwrites an entire property or portfolio of properties, not tenants or individual units. There is no additional credit check, income check, citizen check, or background check. Additionally, pricing is the same for similar units, regardless of whether the tenants are a family of 2 or 8. And finally, if a deposit waiver fee option is offered to one tenant in the building, it is offered to every prospective tenant. Leaselock's goal is to help 100% of tenants avoid the struggle of paying security deposit. We've met with the Maryland Multi-Housing Association, Public Justice Center, and Legal Aid, and the Attorney General's Consumer Protection Division. We're already working on amendments to address concerns that property owners may double dip and bill residents for damages that an insurance claim is already covered. There is, however, one concern raised that likely we cannot address, and that is about an insurer's ability to be reimbursed by the resident after paying. Lease insurance is like all forms of insurance. If another driver hits your car, your insurance company pays for your damage and it seeks repayment of those costs by the other driver's insurance company or the other driver. Leaselock has never requested reimbursement from a tenant or former tenant. Leaselock does not intend to seek that reimbursement. But Leaselock cannot stay in business without maintaining the right to do so, because it is an insurance product. And this is a standard insurance company practice. If that option was removed from law, Leaselock could not offer lease insurance in Maryland and cannot help Marylanders eliminate the security deposit barrier to housing. We believe Senate Bill 892 is a win-win for renters and property owners. It removes a significant barrier to housing by creating an option for residents. We respectfully request a favorable report from the committee, and I'm happy to answer any questions. Thank you.
Thank you, Mr. Graham, for your testimony. I see that our wonderful Chairman Will Smith is back with us, so I will turn this proceeding over to our Chairman, Will Smith. Thank you so much, witnesses and Senator Augustine.
Excellent. Thank you very much, Senator Lee. So we just finished up with, was that the first witness? Is that right?
Our next witness is Josh White. Proceed.
Okay,
Mr.
great. There you go, Mr. White. What's going on?
Good evening, sir. Good afternoon, sir. Madam Chair, Chairman Smith, members of the committee. I'm Josh White. I'm Perry White, Ross, and Jacobson on behalf of LeaseLock. I just want to thank Senator Augustine for sponsoring the bill. We all agree that the most significant barriers to renters that they face are making the upfront payments. This could include first and last month's rent, plus a security deposit. And when renters are able to make those payments, that money will just sit in the bank account, inaccessible to tenants who might desperately need it. So that's why LeaseLock came up with this solution by offering lease insurance that enables landlords to waive the security and damage deposit. And today, thousands of Marylanders have chosen the waiver fee in lieu of a security deposit. So many are asking, well, why the legislation? Why are we doing this today? Well, first, as Chris mentioned, the law is silent on the issue of lease insurance. There is no uncertainty about the legality, but we believe that statutory clarity may encourage adoption of security deposit alternatives that allows many tenants to get into their apartments. And second, we believe that the legislation makes it clear that a security deposit alternative is actually a choice and tenants must opt in. So this bill is really about providing choices as much as possible so that we could help people get into their into their apartments. So Senate Bill 892 does provide clarity in the law, expands alternatives, and really gives choices to tenants. And that's why we urge a favorable report. So thank you very much.
Excellent. Thank you very much. Thank you very much, Mr. White. Next, we'll go to the unfavorable panel, and we'll go with Kira Wellborn. You're up.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the committee. My name is Kira Wellborn. I'm an Assistant Attorney General with the Consumer Protection Division of the Office of the Attorney General of Maryland. The Consumer Protection Act mandates the division to take strong protections and preventative steps to investigate unlawful consumer practices, to assist the public in obtaining relief from these practices, and to prevent these practices from occurring in Maryland. As such, the division mediates and investigates complaints from Maryland consumers regarding unfair, abusive, or deceptive trade practices, and seeks to remediate violations of the Act through enforcement actions and voluntary conciliation agreements. It is from this perspective that I am here today to express the division's opposition to Senate Bill 892. Senate Bill 892 admirably seeks to reduce and remove financial barriers to safe and affordable housing that a security deposit can impose for Maryland consumers. While the division welcomes this committee and the sponsors of this bill's attempts to remove these barriers, the division remains concerned that the bill could allow landlords to engage in unfair and deceptive and abusive practices, and that those risks outweigh any potential benefits to consumers. Specifically, this bill omits many of the consumer protections obtained within Maryland's security deposit and surety bond provisions, such as clear disclosures of rights and responsibilities of the tenant, written notice to the tenant of any damage and debts that are claimed to be the tenant's responsibility, and limits on the amounts that a tenant may be asked to pay upfront for security of the property. While described as a fee in lieu of a security deposit, this fee has very little, if any, relation to a security deposit as consumers know it, thus contributing to the potential unlawful deception. First, unlike a security deposit, the fee can be fully non-refundable. Second, the fee can recur monthly for the duration of the tenancy or be a lump sum upfront payment, often resulting in the tenant paying significantly more than she would have paid if she had paid for the security deposit in the first place. And finally, the payment of this fee does not prevent the tenant from being sued after vacating the unit for alleged damages. Of additional concern, this bill permits but does not require that the landlord use the fee to purchase insurance to cover claims for unpaid rent and damages. Accordingly, a tenant who opts to pay the fee instead of a security deposit may have no way of knowing whether the monthly fee she is paying is securing any protections. Likewise, if the landlord purchases insurance coverage, the tenant may not know who the insurer is or what the coverage has. This information is essential to evaluating whether the monthly fee is beneficial for the consumer. This omission of material information can further harm consumers after they move when either the landlord or an unknown insurance company seeks reimbursement. While the division welcomes a review of Maryland's current security deposit laws in order to remove barriers to affordable housing, any policy change must continue to protect consumers at all stages of a tenancy. For these reasons, the division recommends the committee issue an unfavorable report. Thank you.
Excellent. Thank you very much, Ms. Welborn. And for the final witness for the opposition panel, we have Mr. Hill. Mr. Hill, you're up. Good to see you.
Thank you, Mr. Chair. Good to see you too, Mr. Vice Chair, members of the committee. Again, my name is Matt Hill. I'm an attorney at the Public Justice Center. Public Justice Center is opposed to the bill. We appreciate the intent, however. We appreciate the sponsor raising up this issue of security deposits and the huge barrier that security deposits create for our clients who often need to move to get out of uninhabitable conditions or to flee from domestic violence. And those upfront costs are significant, and it's a significant issue for our clients. So I appreciate the intent. Our concern with the product, this kind of security deposit alternative or whatever it is that we're calling this, is that in our experience, there is often a dispute between the landlord and the tenant over whether or not certain fees were due or whether or not certain damage was caused by the tenant or above wear and tear, what constitutes ordinary wear and tear. And so right now, landlords often withhold significant amounts from the security deposit. As I understand this, the lease lock product, what happens is after the tenant moves out, if the landlord claims there are certain damages or certain unpaid fees, the landlord puts in a claim with lease lock, and then lease lock has the authority to go after the tenant. Now, my concern in that situation is that the tenant loses a lot of their ability to counterclaim against the landlord or to bring defenses that often rely on the knowledge and documents that are within the possession of the landlord. And so from that very practical perspective, because we do see so many disputes over security deposits, we're very concerned that that tenants lose in that situation. I know what lease lock is saying, that they don't do that, they don't come after the tenants, but their contracts allow them to do so. And so I'm sure that their intent right now is good, but I do wonder if there's not some sort of guardrail there that they will come after tenants, and tenants will essentially be sued, and then there's a money judgment, and then their wages are garnished, and they're essentially moving further down that hole. Similarly, this is marketed as insurance, but at least from the perspective of a tenant, I know that this is just a very hard concept to understand in some ways. The tenant's not being insured. They're paying the premium, but they're not actually getting a benefit of the insurance, because if there's a claim, they still have to pay the claim. And so maybe this is just my own ignorance, but I still don't quite understand what they're paying the premium, but they're not getting the benefit of coverage in the way we normally think of insurance. So I think it's a confusing product, and that disclosure would be very helpful along those lines. And having said all that, we worked with lease lock. We're willing to have a continuing dialogue with lease lock. Security deposits are a major problem. Thank you.
Excellent. So with that, that'll conclude the testimony for the bill. I'll turn over to the committee for questions. Seeing none, that'll conclude the hearing. Thank you very much. Thank you, Senator Augustine. See you all later. Thank you to the panelists. All right, I believe that brings us up to the last bill of the day, Senate Bill 911, which is my bill, and I see that Mr. Simpson's here, so I'll get started. So for the record, Senator Smith, on behalf, here to present Senate Bill 911. So this bill has essentially three parts. First, the bill repeals the limitations on the amount of compensatory and punitive damages that may be awarded to a plaintiff in cases for unlawful unemployment practices. Two, the bill increases from 2 to 3 years the amount of back pay that can be awarded in the case. And then finally, three, it increases from 2 to 3 years the time within which the person can file a civil action in circuit court after the alleged unlawful employment practice actually occurred. And then I would say finally, and then it removes the caps for compensatory and punitive damages. So going into why this is necessary, the last time that we kind of adjusted the cap was back in 1991. And in your fiscal note, there's a chart that kind of walks you through kind of the number of employees and the cap for that business associated with that number. I'll go through that toward the end. But the anti-discrimination law, it basically followed Title VII, and the ultimate cap is $300,000. Again, implemented in 1991, and the cap hasn't moved since. So, so the equivalent of $300,000, according to like the consumer price index, would be $583,000 today. So when you look at it, the damage cap has been effectively cut in half just because of 30 years of patches of time. At the same time, there remains a general statutory cap for non-economic damages above 800 for other torts. So we did that a couple of years ago. You'll remember when we did the Local Tort Claims Act and the State Tort Claims Act, when we adjusted those caps, I think in 2016. And then we also had provided for an escalator clause so that it would escalate, or that number would bump up $15,000 each year. So this bill would put victims of discrimination on par with other victims of other sorts of harm where there's a cap for damages and where that hasn't kept pace in this instance. We recognized it within the realm of torts, and so this bill seeks to kind of make sure that other claims for damages and discrimination are kind of on par with that. Maryland has done this. And then let me say one other thing that the bill does, or one of the reasons behind the actual increase for the statute of limitations, which is kind of the second half of the bill. We've recently increased the statute of limitations for harassment cases to 3 years, and this bill would bring those claims of discrimination in line with that time period. And which is just an understanding that there's no general reason to have different statutes of limitations for different kinds of discrimination. Which I'm sure that Mr. Simpson will point out, this would reduce confusion where individuals in courts would have had to have separate out causes of action and distinguish between issues where there are sometimes no clear breaks. Some cases even hold that a termination or a demotion can be part of a hostile work environment claim. So just understanding that there's a distinction there could cause confusion, and making these things in line would just kind of clarify and streamline that process. With that, I'll say this. It also increases the amount of back pay, since we've done now we've bumped the statute of limitations to file a claim to 3 years. It just does the same thing for back pay. Right now, you can only get 2 years. This bumps it back to 3 years. Would make sense if you're giving them another year to kind of file, then another year would have gone that the person was aggrieved, and they're entitled to an additional year. So again, going back to where I started in terms of the caps right now. So right now, the caps are $50,000 for respondents with 15 to 100 employees. It's $100,000 for businesses or respondents with employees of 101 to 200 employees, $200,000 for 201 employees to 500 employees, and then $300,000 for businesses or respondents for 501 employees or more. So the most controversial piece of this bill is just because the bill seeks to just remove those caps altogether. Instead of doing that, we could look at the current statute and compute using the consumer price index what those $1991 would be in 2021, and do the same thing we did with the Local Tort Claims and the State Tort Claims Act, which have a $15,000 escalator clause for each year. So they're going to have to keep coming back every 10 years, every 5 years to make sure that the value of the dollar that's awarded hasn't gone down. And that's certainly in line with the policy intentions of the General Assembly in 1991, and that's in keeping with that. So with that, I'll ask for a favorable report and turn it over to Mr. Simpson for his testimony. Mr. Simpson, you're up.
Senator Smith, and I'm here on behalf of the Metropolitan Washington Employment Lawyers Association. That's a association of more than 300 lawyers in the DC area. And our main line of work is representing folks who have been subject to unlawful employment actions. And MELA seeks a favorable referral of the bill. And for many of the reasons that Senator Smith said, and I don't know how many folks here are law school graduates, but I want to give a hypothetical to kind of illustrate the point and maybe give you flashbacks, positive or negative, to back to law school. Maybe there were glory days. Imagine that there's a woman working for a large company, and I've had cases similar to this, in that she's sent on to a conference out of town with her boss, and her boss, while out of town, sexually assaults her. And as a result of that sexual assault, she suffers PTSD. She can't sleep for months at a time. She can't eat, and her life is totally upended. She requires medical treatment, and she is devastated. She takes some time, and then she brings to the courage to tell the company what happened. And after she does that, the company fires her. And now has suffered this sexual assault, and she's out on the street. She's looking for a job, and hopefully she gets back on her feet. Now, this woman, if she came to my office, we would say that, well, you have to file a charge of discrimination within 6 months. And that charge of discrimination would involve both the harassment, the assault, and it would involve kind of the retaliatory termination. So she would have two different types of claims. She would have a retaliation claim, and she would have a harassment claim. And you go to the Montgomery, either Montgomery County or the Maryland Commission on Civil Rights, and they take the time to investigate. It's not an immediate turnaround. And you can wait there and wait for mediation, wait for other resolution investigation, and you can be pressing up on 2 years before there's an investigation that's been completed. And you're faced with a decision. You would file one set of claims while the other one is still being investigated, and you would not have allowed the Maryland Commission on Civil Rights to do its job before you're required to pull the claim, or else you'll be splitting your claim, and you can run into trouble with judges if you do that. Now, so you're forced to pull your claim early, you file in court, and then things go well, you win a judgment. And the jury comes back with a verdict of $500,000 because of the grievous injury that this woman has suffered. The judge would then take that $500,000, what the jury decided was the appropriate amount of compensation, and say, no, you can only get a maximum of $300,000. And so you are not fully compensated. That same $500,000 in 1991, when the Civil Rights Act was passed in federal law, would be less than $300,000. So on a dollar per dollar basis, she would not have recovered fully, even though that was the intent back in 1991 under the federal law. So what this bill would do it would allow the Maryland Commission on Civil Rights to do its job and investigate more fully, give more time. It would reduce the amount of confusion about, there are several cases where it's hard to tell if this is a harassment or discrete act, so you bring both, and then you don't know kind of what your limitations period is. And it's hard enough for a lawyer to figure that out, but in many cases, people are not represented, they wouldn't know. And so anything that we can do to simplify that would aid employees in the state of Maryland. And it would allow for that woman to be more fully compensated, and so that she would not be subject to the cap where if she was a car crash victim, and had pain and suffering, that she would be more fully compensated. And so those are the reasons why MELA is seeking a favorable referral.
Excellent. Thank you very much, Mr. Simpson. And again, for the committee, those amendments are not before you yet, but I will have them drafted. And I think those amendments should address at least part of the Chamber of Commerce's, their opposition to the bill with respect to the caps. it also is in line with, I think, with good policy, and it doesn't completely destroy the caps. So that, I think that'll be good. I'll reach out to them again, but you'll notice that was the only opposition in the bill file. So with that, that'll conclude the testimony for Senate Bill 911. Turn to the committee for questions. Okay, excellent. Senator Cassidy.
Wait, so the only opposition, I think that I saw the chamber send a letter, but that's the only opposition we've got, I think, right? Is the chamber's letter?
That's right. And it's two-part, one to the statute of limitations, one mainly is the caps. And it's because the bill sought to just completely remove the caps. But I think with this new, if you just, as we discussed, use the consumer price index, just match it to what contemporary money would be worth.
Right.
That's aligned with policy that we sought to implement in 1991. And it's just, that's fairness. That's basic fairness. I mean, the dollar isn't worth the same thing back in 1991 as it is today. So,
Yeah, I guess I look at the proposal and I'm just curious that, so there is a, punitive damages can be awarded, but those are limited. So I understand your desire to remove the punitive limitation. I mean, if punitives require actual malice. So if you went after this person to screw with them intentionally, but then I guess I've been so many years since I did one of these. So in order to prevail, the plaintiff in one of these actions would have to prove that the I mean, it could just be, it could be sort of a de facto discrimination, right? It's just that they could establish that disparate impact kind of an award for an award under the statute, right?
So, if I may.
Yep.
Most of the time in a disparate impact kind of case, that there usually aren't compensatory damages there. So if you have a kind of employment policy that favors, one protected category over another, to my understanding and the practice that I've had, that compensatory damage kind of for the emotional harm are usually not available in those sorts of cases. It's usually in the case of intentional discrimination where, there is I'm firing you, and, then the court figures out why, and if it was because of your race or sex or national origin or sexuality or the like for the protected categories, then in that case, there would be compensatory damages for the emotional harm caused. And so this is typically directed to those sorts of cases.
And it's interesting statute because you can go through an administrative proceeding, and then if you go through that, you can still file, like, let's say I go through administrative proceeding and I don't like the result. Can I then file a civil action? How does that work?
So I don't know off the top of my head in Maryland if that is something that I've never heard of having been done.
Okay.
So
I proceed under the administrative,
usually,
and if I have an election then to go administrative or a civil jury or civil trial then.
You are required to go to one of the administrative agencies. So, there's a time limit where you can opt out. So there would be the ordinary way that it would go is that you're required to file, for example, with the Maryland Commission on Civil Rights within 6 months, and then they conduct an investigation, and that investigation can take a year, 2 years, however long. I've had one that's been outstanding for 4 years. And, however, when that is ongoing, so you have to wait for it to be before the commission for at least 180 days before you're allowed to file a lawsuit. So if the Maryland Commission on Civil Rights hasn't done anything, then you're allowed to go ahead and file a lawsuit. I don't think it's the case that because there is a process for adjudication within the Maryland Commission on Civil Rights, where they actually kind of hear testimony and kind of get to the merits of the claim. And I think that if they find against you, I do not think that you can then go ahead and file a lawsuit. But I've never, I've been doing this for 15 years. I never heard of that happen.
I mean, I guess I'm looking, so you're kind of where my question comes down to is, if you proceed through the administrative remedy, currently your damages are limited. And then if you go to the jury trial, you're subject to those same limitations. Isn't that right, how the statute currently works?
That is how the statute currently works, yes.
All right.
And so the bill hopefully would, sorry.
I mean, it would seem to me that we would want to encourage one route, try to do this in the administrative law, and we encourage you to do that by giving you, capping your damages, but it'll be administrative, it'll be fast, cheaper, less formal. But if you don't want to do that, you can go to if you want to go for bigger damages, bigger than the caps, that you would then go through the courts and go through all the formality of that. Do other states do it that way? In an effort to encourage people to move these cases through administrative law forum?
So I want to make sure that I understand the question is and so I'm going to restate it and you can correct me if I'm wrong. Okay. The question is whether other states have different damages available based on whether you go kind of through completion in the administrative forum versus going to court. And
that's right. Yes.
Yeah. So I'm not aware of any other states or jurisdictions that do that formally. I know that there are, kind of the analog that I would say would be kind of in the federal sector, where Maryland has many federal employees, is that there's no formal difference in the law about the remedies available, but you can rest assured that administrative judges award damages differently than juries might. They know about the cap. So yeah.
What's your line of thought here? Are you suggesting that I think we definitely need to adjust the caps, right? But are you suggesting that we kind of develop a different
I would think,
if you were to go,
we want to encourage people to go into administrative law to resolve the problem where they don't need to spend fortunes on litigation and expedite it through the administrative process. But if somebody says, well, look, no, I am so aggrieved, there's no way that's going to give me the kind of damages. I'm looking for big bucks here. Then okay, we're going off to court. But if my damages are the same at administrative or it seems, I don't know, it seems odd to me that we would have the same damages in administrative forum versus the through the courts, that normally the administrative forum, you think of as get this done. I can pick up a reasonable, I would feel like my rights were protected. I was vindicated. I'm not going to be able to retire on this, but I get a good result versus, this was so outrageous. Screw your penny ante stuff. I'm going for millions. I'm going to shut your company down. And then, I don't know.
I'm sure they'd be amenable to something like that. We'll
okay.
I'm sure I'm talking about
the litigation costs are just so debilitating, and that if people can say, "Oh, we're in this forum, and here's where it's like the difference between the district court and the circuit court. The district court matter, everything's pretty well defined. We know where it is. People don't go lawyer up to the hilt. The most you're going to lose is a certain amount. So keep everything reasonable. Don't spend a fortune and just hope that justice prevails. Versus the circuit court where you got a lawyer up to the hilt because the sky's the limit on what you can get. So I'm just surprised that we're dealing with the same in the statute. I'm in for expedited quick hit. I got fairly compensated. I didn't need to have Clarence Darrow in there and a full legal team. I could go in and get a fair compensation and move it along quickly. And so anyway, all right. Thank you, Mr. Chairman. I appreciate it.
Yep. We all do see ourselves as Clarence Darrow for the record.
That's awesome. All right. With that, any further questions? Seeing none, thank you, Mr. Simpson. We'll be in touch soon, and thank you to the committee. With that, that'll conclude the hearing for Senate Bill 911, and our hearings for the day. Sandy, is that right? Double check me on that.
That is correct.
I know we got one thing going on here. So I know, so what we do, looks like we're going on the floor at 6, but we need to get the Baltimore City Police Department bill out of committee. So I'd ask if members could come down in 15 minutes for a quick, what I hope will be a quick voting session to vote this bill out, so that we can have it on the floor. We'll do it before 6 o'clock. So let's call it 5:20. Can folks come down? Is that agreeable for everyone? Hopefully it won't be a long time. Okay, great. See you guys down here in 20 minutes. All right. Have a good one.